causing the puppet theater to react. So first, let me say, why do I think outside forces are here pulling strings? Well, part of it is behavior. We have colleagues here who supported you, this nominee, before there was a nominee. That's a little unusual. We have the political ram job that we have already complained of, driving this process through at breakneck speed in the middle of a pandemic while the Senate is closed for safety reasons and while we're doing nothing about the COVID epidemic around us. We have some very awkward 180s from colleagues. Mr. Chairman, you figure in this. Our leader said back when it was Garland versus Gorsuch that of course, the American people should have a say in the court's direction. Of course, said Mitch McConnell. That's long gone. Senator Grassley said the American people shouldn't be denied a voice. That's long gone. Senator Cruz said, you don't do this in an election year. That's long gone. And our chairman made his famous hold the tape promise, if an opening comes in the last year of President Trump's term, we'll wait till the next election. That's gone too. So there is a lot of hard to explain hypocrisy and rush taking place right now. And my experience around politics is that when you find hypocrisy in the daylight, look for power in the shadows. Now, people may say, well, what does all this matter? This is a political parlor game. It's no big deal. Well, there's some pretty high stakes here that we've been talking about here on our side. And I'll tell you three of them right here. Roe versus Wade, Obergefell, and the Obamacare cases. Here's the GOP platform, the Republican platform. The platform of my colleagues on the other side of this aisle say that a Republican president will appoint judges who will reverse Roe, Obergefell, and the Obamacare cases. So if you have a family member with an interest in some autonomy over their body under Roe versus Wade, the ability to have a marriage, to have friends marry, to have a niece or a daughter or a son marry someone of their same sex, you've got a stake. And if you're one of the millions and millions of Americans who depend on the Affordable Care Act, you've got a stake. It's not just the platform. Over and over again, let's start by talking about the Affordable Care Act. Here's the president talking about this litigation that we're gearing up this nominee for November 10th. In this litigation, he said, we want to terminate health care under Obamacare. That is the president's statement. So when we react to that, don't act as if we're making this stuff up. This is what President Trump said. This is what your party platform says. Reverse the Obamacare cases. Senator after senator, including many in this committee, filed briefs saying that the Affordable Care Act should be thrown out by courts. Why is it surprising for us to be concerned that you want this nominee to do what you want nominees to do? One quick stop on NFIB v. Sebelius, because a lot of this has to do with money. This is an interesting comparison. National Federation of Independent Businesses, until it filed the NFIB versus Sebelius case, had its biggest donation ever of $21,000. In the year that it went to work on the Affordable Care Act, 10 wealthy donors gave $10 million. Somebody deserves a thank you. So let's go on to Roe v. Wade. Same thing. Same thing. The president has said that reversing Roe v. Wade will happen automatically because he's putting pro-life justices on the court. Why would we not take him at his word? The Republican Party platform says it will reverse Roe. Why would we not comment on that and take you at your word? Senators here, including Senator Hawley, have said, I will vote only for nominees who acknowledge that Roe v. Wade is wrongly decided. And they're pledged to vote for this nominee. Do the math. That's a really simple equation to run. The Republican brief in June Medical said Roe should be overruled. So don't act surprised when we ask questions about whether that's what you're up to here. And finally, out in the ad world that you have spared yourself wisely, Judge Barrett, the Susan B. Anthony Foundation is running advertisements right now saying that you are set to give our pro-life country the court that it deserves. There's the ad with the voiceover. She's set. She's set. And then Roe, Obamacare cases, and Obergefell, gay marriage. National Organization for Marriage, the big group that opposes same-sex marriage, says in this proceeding, all our issues are at stake. The Republican platform says it wants to reverse Obergefell. And the Republican brief filed in the case said same-sex relationships don't fall within any constitutional protection. So when we say the stakes are high on this, it's because you've said the stakes are high on this. You have said that's what you want to do. So how are people going about doing it? What is the scheme here? Let me start with this one. In all cases, there's big anonymous money behind various lanes of activity. One lane of activity is through the conduit of the Federalist Society. It's managed by a guy, was managed by a guy named Leonard Leo, and it's taken over the selection of judicial nominees. How do we know that to be the case? Because Trump has said so over and over again. His White House counsel said so. So we have an anonymously funded group controlling judicial selection run by this guy, Leonard Leo. Then in another lane, we have, again, anonymous funders running through something called the Judicial Crisis Network, which is run by Carrie Severino, and it's doing PR and campaign ads for Republican judicial nominees. It got single $17 million donation in the Garland-Gorsuch contest. It got another single $17 million donation to support Kavanaugh. Somebody, perhaps the same person, spent $35 million to influence the makeup of the United States Supreme Court. Tell me that's good. And then over here, you have a whole array of legal groups, also funded by dark money, which have a different role. They bring cases to the court. They don't wind their way to the court, Your Honor. They get shoved to the court by these legal groups, many of which ask to lose below so they can get quickly to the court to get their business done there. And then they turn up in a chorus, an orchestrated chorus of amici. Now, I've had a chance to have a look at this, and I was in a case, actually, as an amicus myself, the Consumer Financial Protection Board case. And in that case, there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 amicus briefs filed, and every single one of them was a group funded by something called Donors Trust. Donors Trust is a gigantic identity scrubbing device for the right wing so that it says Donors Trust is the donor without whoever the real donor is. It doesn't have a business. It doesn't have a business plan. It doesn't do anything. It's just an identity scrubber. And this group here, the Bradley Foundation, funded 8 out of the 11 briefs. That seems weird to me when you have amicus briefs coming in little flotillas that are funded by the same groups but nominally separate in the court. So I actually attached this to my brief as an appendix. Center for Media and Democracy saw it, and they did better work. They went on to say which foundations funded the brief writers in that CFPB case. Here's the Bradley Foundation for $5.6 million to those groups. Here's Donors Trust, $23 million to those brief writing groups. The grand total across all the donor groups was $68 million to the groups that were filing amicus briefs, pretending that they were different groups. And it's not just in the Consumer Financial Protection Board case. You might say, well, that was just a one-off. Here's Janus, the anti-labor case that had a long trail through the court, through Friedrichs and through Knox and through other decisions. And SourceWatch and ProPublica did some work about this. Here's Donors Trust and Donors Capital Fund, and here's the Bradley Foundation, and they totaled giving $45 million to the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 groups that filed amicus briefs pretending to be different groups, and both of the lawyer groups in the case. Funded by Donors Trust, funded by Bradley Foundation in Janus. This is happening over and over and over again, and it goes beyond just the briefs. It goes beyond just the amicus presentations. The Federalist Society, remember this group that is acting as the conduit and that Donald Trump has said is doing his judicial selection? They're getting money from the same foundations. From Donors Trust, $16.7 million. From the Bradley Foundation, $1.37 million. From the same group of foundations total, $33 million. So you can start to look at these and you can start to tie them together. The legal groups, all the same funders over and over again, bringing the cases and providing this orchestrated chorus of amici. Then, the same group also funds the Federalist Society over here. The Washington Post wrote a big expose about this, and that made Leonard Leo a little hot, a little bit like a burned agent. So he had to jump out, and he went off to go and do anonymously funded voter suppression work. Guess who jumped in to take over the selection process in this case for Judge Barrett? Carrie Severino made the hop. So once again, ties right in together. So Center for Media and Democracy has done a little bit more research. Here's a Bradley Foundation memo that they've published. The Bradley Foundation is reviewing a grant application asking for money for this orchestrated amicus process. And what do they say in the staff recommendation? It is important to orchestrate, their word, not mine, important to orchestrate high-caliber amicus efforts before the court. They also note that Bradley has done previous philanthropic investments in the actual underlying legal actions. So Bradley is funding, what do they call, philanthropically investing in the underlying legal action and then giving money to groups to show up in the orchestrated chorus of amici. That can't be good. And it goes on, because they also found this email. This email comes from an individual at the Bradley Foundation, and it asks our friend Leonard Leo, who used to run the selection process, is there a 501c3 nonprofit to which Bradley could direct any support of the 2 Supreme Court amicus projects other than Donors Trust? I don't know why they wanted to avoid the reliable identity scrubber Donors Trust, but for some reason they did. So Leonard Leo writes back on Federalist Society address. So don't tell me that it isn't Federalist Society business. On Federalist Society, on his address, he writes back, yes, send it to the Judicial Education Project, which could take and allocate the money. And guess who works for the Judicial Education Project? Carrie Severino, who also helped select this nominee running the Trump Federalist Society selection process. So the connections abound. In the Washington Post article, they point out that the Judicial Crisis Network's office is on the same hallway in the same building as the Federalist Society, and that when they sent their reporter to talk to somebody at the Judicial Crisis Network, somebody from the Federalist Society came down to let them up. This, more and more, looks like it's not 3 schemes, but it's 1 scheme, with the same funders selecting judges, funding campaigns for the judges, and then showing up in court in these orchestrated amicus flotillas to tell the judges what to do. On the Judicial Crisis Network, you've got the Leonard Leo connection, obviously. She hopped in to take over for him with the Federalist Society. You've got the campaigns that I've talked about, where they take $17 million contributions. That's a big check to write, $17 million. To campaign for Supreme Court nominees. No idea who that is or what they got for it. You've got briefs that she wrote. The Republican senators filed briefs in that NFIB case signed by Ms. Severino. The woman who helped choose this nominee has written briefs for Republican senators attacking the ACA. Don't say the ACA is not an issue here. And by the way, the Judicial Crisis Network funds the Republican Attorneys General. It funds RAGA, the Republican Attorney General's Association, and it funds individual Republican Attorneys General. And guess who the plaintiffs are in the Affordable Care Act case? Republican Attorneys General. Trump joined them because he didn't want to defend, so he's in with the Republican Attorneys General. But here's the Judicial Crisis Network campaigning for Supreme Court nominees, writing briefs for senators against the Affordable Care Act, supporting the Republicans who are bringing this case, and leading the selection process for this nominee. Here's the page off the brief. Here's where they are. Mitch McConnell, and on through the list. Senator Collins, Senator Cornyn, Senator Hoeven, Senator, who's still here? Marco Rubio. It's a huge assortment of Republican senators who Carrie Severino wrote a brief for against the Affordable Care Act. So this is to me, pretty big deal. I've never seen this around any court that I've ever been involved with, where there's this much dark money and this much influence being used. Here's how the Washington Post summed it up. This is a conservative activist behind-the-scenes campaign to remake the nation's courts, and it's a $250 million dark money operation. $250 million is a lot of money to spend if you're not getting anything for it. So that raises the question, what are they getting for it? Well, I showed the slide earlier on the Affordable Care Act and on Obergefell and on Roe versus Wade. That's where they lost. But with another judge, that could change. That's where the contest is. That's where the Republican Party platform tells us to look at how they want judges to rule, to reverse Roe, to reverse the Obamacare cases, and to reverse Obergefell and take away gay marriage. That is their stated objective and plan. Why not take them at their word? But there's another piece of it, and that is not what's ahead of us, but what's behind us. What's behind us is now 80 cases, Mr. Chairman, 80 cases under Chief Justice Roberts that have these characteristics. One, they were decided 5-4 by a bare majority. Two, the 5-4 majority was partisan in the sense that not one Democratic appointee joined the 5. I refer to that group as the Roberts 5. It changes a little bit, as with Justice Scalia's death, for instance, but there's been a steady Roberts 5 that has delivered now 80 of these decisions. And the last characteristic of them is that there is an identifiable Republican donor interest in those cases. And in every single case, that donor interest won. It was an 80-0, 5-4 partisan rout, ransacking. And it's important to look at where those cases went, because they're not about big public issues like getting rid of the Affordable Care Act, undoing Roe versus Wade, and undoing same-sex marriage. They're about power. And if you look at those 80 decisions, they fall into 4 categories over and over and over again. 1, unlimited and dark money in politics. Citizens United is the famous one, but it's continued since with McCutcheon, and we've got one coming up now. Always the 5 for unlimited money in politics, never protecting against dark money in politics, despite the fact that they said it was going to be transparent. And who wins when you allow unlimited dark money in politics? A very small group. The ones who have unlimited money to spend and a motive to spend it in politics. They win, everybody else loses. And if you're looking at who might be behind this, let's talk about people with unlimited money to spend and a motive to do it. We'll see how that goes. Next, knock the civil jury down. Whittle it down to a nub. The civil jury was in the Constitution, in the Bill of Rights, in our darn Declaration of Independence. But it's annoying to big corporate powers because you can swagger your way as a big corporate power through Congress. You can go and tell the president you put money into to elect what to do. He'll put your stooges at the EPA. It's all great until you get to the civil jury, because they have an obligation, as you know, Judge Barrett. They have an obligation under the law to be fair to both parties, irrespective of their size. You can't bribe them. You're not allowed to. It's a crime to tamper with a jury. It's standard practice to tamper with Congress. And they make decisions based on the law. If you're used to being the boss and swaggering your way around the political side, you don't want to be answerable before a jury. And so one after another, these 85-4 decisions have knocked down, whittled away at the civil jury, a great American institution. Third, first was unlimited dark money. Second was demean and diminish the civil jury. Third is weaken regulatory agencies. A lot of this money, I'm convinced, is polluter money. The Coke Industries is a polluter. The fossil fuel industry is a polluter. Who else would be putting buckets of money into this and wanting to hide who they are behind donors' trust or other schemes? And what if you're a big polluter, what do you want? You want weak regulatory agencies. You want ones that you can box up and run over to Congress and get your friends to fix things for you in Congress. Over and over and over again, these decisions are targeted at regulatory agencies to weaken their independence and weaken their strength. And if you're a big polluter, a weak regulatory agency is your idea of a good day. And the last thing is in politics, in voting. Why on earth the court made the decision a factual decision, not something appellate courts are ordinarily supposed to make, as I understand it, Judge Barrett, the factual decision that nobody needed to worry about minority voters in pre-clearance states being discriminated against or that legislators would try to knock back their ability to vote. These 5 made that finding in Shelby County against bipartisan legislation from both houses of Congress, hugely passed on no factual record. They just decided that that was a problem that was over on no record, with no basis, because it got them to the result that we then saw. What followed? State after state after state passed voter suppression laws. One so badly targeting African Americans that the 2 courts said it was surgically tailored to get after minority voters. And gerrymandering, the other great control. Bulk gerrymandering, where you go into a state, like the Red Map Project did in Ohio and Pennsylvania, and you've sent a delegation to Congress that is out of step with the popular vote of that state. And court after court figured out how to solve that, and the Supreme Court said, nope, 5-4 again, nope, we're not going to take an interest in that question. In all these areas where it's about political power for big special interests and people who want to fund campaigns, and people who want to get their way through politics without actually showing up, doing it behind donors' trust and other groups, doing it through these schemes, over and over and over again, you see the same thing. 80 decisions, Judge Barrett. 80 decisions, an 80-0 sweep. I don't think you've tried cases, but some cases, the issue is bias and discrimination. And if you're making a bias case, as a trial lawyer, Lindsey Graham is a hell of a good trial lawyer. If he wanted to make a bias case, Dick Durbin's a hell of a good trial lawyer. If they wanted to make a bias case and they could show an 80-0 pattern, A, that's admissible, and B, I'd love to make that argument to the jury. I'd be really hard-pressed to be the lawyer saying, no, 80-0 is just a bunch of flukes. All 5-4, all partisan, all this way. So something is not right around the court. And dark money has a lot to do with it. Special interests have a lot to do with it. Donors' trust and whoever's hiding behind donors' trust has a lot to do with it. And the Bradley Foundation orchestrating its amici over at the court has a lot to do with it. So I thank you, Judge Barrett, for listening to me now a second time. And I think this gives you a chance for you and I to tee up an interesting conversation tomorrow. And I thank my colleagues for hearing me out.
Thank you, Senator Whitehouse. Senator Cruz.
Oh, Mr. Chairman, can I put 3 letters in unanimous consent?
Without objection.
Thank you.
Thank you, Mr. Chairman. Judge Barrett, welcome. Congratulations on being nominated. Congratulations on enduring the confirmation proceedings. And I think it is a particularly good thing. We've made it through what I guess you would call the top of the lineup of the questioning. And some of the smartest and frankly most effective questioners on the Democratic side, and I think it speaks volumes that collectively they have had very few questions for you.
And most effective. He's getting back.
And virtually none calling into question your credentials, which are impeccable.
Didn't make the cuts.
Your record, and what I think has been an extraordinary life you've led. So that should be the source of great satisfaction in terms of the scholarly record and judicial record that you've spent a lifetime building. I want to start by asking you a question. Why is the First Amendment's protection of religious liberty, why is that important?
Well, I think it's broadly viewed that the framers protected and ratifiers protected the free exercise of religion because, for reasons that we all know from history of persecuted religious minorities fleeing to the United States, that enshrining that protection, it was one of the Bill of Rights because it was considered so fundamental.
And why does that matter to Americans? What difference does that make in anybody's life?
Well, I think all of the Bill of Rights, each and every one of them, is important to Americans because we value the Constitution, including religious liberty.
Well, how about the free speech protections of the First Amendment? Why are those important?
So that minority viewpoints can't be squashed, so that it's not just the majority that can speak popular views. You don't really need the First Amendment if what you're saying is something that everybody wants to hear. You need it when people are trying to silence you.
And how about the Second Amendment? Why is the right to keep and bear arms important?
Well, we talked about Heller earlier this morning, and what Heller tells us is that the Second Amendment protects an individual right to bear arms for self-defense.
Well, I think all of those rights, and I agree with you, the entire Bill of Rights is incredibly important to Americans. I also think what is really striking about this hearing today and also yesterday is that Senate Democrats are not defending what I think is really a radical agenda that they have when it comes to the Bill of Rights. And the topics they're discussing today have little bearing to the rights that are really at issue and in jeopardy at the Supreme Court. And so let's take a few minutes to go through them. First of all, we've had some discussion of Roe versus Wade. You have declined to give an opinion on a matter that might be pending before the court. That is, of course, the same answer that every single sitting justice has given when he or she was sitting in the same chair you are. It is mandated by the judicial canons of ethics. Whether one is a nominee of a Democratic president or a Republican president, that has been the answer that has been given to this committee for decades. But I do think it is interesting that our Democratic colleagues, number one, don't discuss what would actually happen if there came a day in which Roe versus Wade were overruled, which is namely that it would not suddenly become the case that abortion was illegal, but rather it would revert to the status of the law as it's been for nearly 200 years of our nation's history, which is that the question of the permissibility of abortion is a question for elected legislatures at the state levels and at the federal level. And it is difficult to dispute that there are a great many jurisdictions, including jurisdictions like California and New York, who, even if Roe versus Wade were no longer the law of the land, their elected legislatures would almost certainly continue unrestricted access to abortion with virtually no limitations. What I find interesting, though, is that our Democratic colleagues do not discuss what is really the radical position of the most liberal justices on the Supreme Court, which is that no restrictions whatsoever are permissible when it comes to abortion. Yesterday, one of the Democratic senators made reference to the case Gonzalez versus Carhart. I'm quite familiar with that case, and I represented Texas and a number of other states as amici in that case. That case concerned the constitutionality of the federal ban on partial birth abortion. That was legislation that passed Congress, was signed into law, that made the really gruesome practice of partial birth abortion illegal. Overwhelming majority of Americans believe partial birth abortion should be prohibited, even those who identify as pro-choice. A significant percentage of Americans don't want to see that gruesome practice allowed. Supreme Court, by a vote of 5-4 in Carhart versus Gonzalez, upheld the federal ban on partial birth abortion. That means there were 4 justices ready to strike it down, ready to conclude that you can't ban partial birth abortion, that you can't ban late-term abortion. And by the way, other restrictions that are at question include parental consent laws, parental notification laws. None of our Democratic colleagues want to talk about the justices they want to see on the court would strike down every single reasonable restriction on unlimited abortion on demand that the vast majority of Americans support. How about free speech? Well, we've heard quite a bit about free speech. The senator from Rhode Island just gave a long presentation, complete with lots of charts. I'll say a couple of things on free speech. First of all, our Democratic colleagues, when they address the issue of so-called dark money and campaign finance contributions, are often deeply, deeply hypocritical and don't address the actual facts that exist. Here are some facts. Of the top 20 organizations spending money for political speech in the year 2016, 14 of them gave virtually all of their money to Democrats, and another 3 split their money evenly. So only 3 of the top 20 gave money to Republicans. What did that mean in practice? That meant the top 20 super PAC donors contributed $422 million to Democrats and $189 million to Republicans. Those who give these impassioned speeches against dark money don't mention that their side is funded by dark money with a massive differential. The senator from Rhode Island talked about big corporate powers without acknowledging that the contributions from the Fortune 500 in this presidential election overwhelmingly favor Joe Biden and the Democrats, without acknowledging that the contributions from Wall Street in this election overwhelmingly favor Joe Biden and the Democrats. It's an awful lot of rhetoric about power. But it gets even more interesting when you look at Supreme Court nominations. We just heard an attack on the Federalist Society, a group that I've been a member of for over 25 years. I joined as a law student. It's a group that brings conservatives, libertarians, constitutionalists together to have robust discussions about the Constitution and about the law. What's interesting is nowhere in the Senator of Rhode Island's remarks was any reference to a company called Arabella Advisors, which is a for-profit entity that manages nonprofits, including the 1630 Fund and the New Venture Fund. Now, what on earth are those? Those sound like awfully dark and confusing names. Well, according to the Wall Street Journal this Sunday, in the year 2017 and 2018, those entities reported $987.5 million in revenue. That's nearly $1 billion. We heard a lot of thundering indignation at what was described as $250 million of expenditures. In this case, you've got $1 billion. The senator of Rhode Island said that much money, much of which is dark money that we don't know who contributed it, he asked, what are they getting for it? And by the way, one of the things they're getting for it is a group called Demand Justice, a project of those entities, spent $5 million opposing Justice Brett Kavanaugh and has just launched a 7-figure ad buy opposing your confirmation. So all of the great umbrage about the corporate interests are spending dark money is wildly in conflict with the actual facts that the corporate interests that are spending dark money are funding the Democrats by a factor of 3 to 1 or greater. A fact that doesn't ever seem to be acknowledged. But not only that, what was Citizens United about? You know, it's interesting, most people at home, they've heard about Citizens United. They know it makes Democrats very, very upset. But they don't actually know what the case is about. Citizens United concerned whether or not it was legal to make a movie criticizing a politician. Specifically, Citizens United is a small nonprofit organization based here in D.C. that made a movie that was critical of Hillary Clinton. And the Obama Justice Department took the position that it could punish Citizens United for daring to make a movie critical of a politician. The case went all the way to the U.S. Supreme Court. At the oral argument, there was a moment that was truly chilling. Justice Sam Alito asked the Obama Justice Department, is it your position, under your theory of the case, that the federal government can ban books? And the Obama Justice Department responded, yes. Yes, it is our position that if the books criticize a political candidate, a politician, the federal government can ban books. As far as I'm concerned, that is a terrifying view of the First Amendment. Citizens United was decided 5-4. By a narrow 5-4 majority, the Supreme Court concluded the First Amendment did not allow the federal government to punish you for making a movie critical of a politician. And likewise, that the federal government couldn't ban books. 4 justices dissented. 4 justices were willing to say the federal government can ban books and can ban movies and presumably could ban books as well. When Hillary Clinton was running for president, she explicitly promised every justice she nominated to the court would pledge to overturn Citizens United. By the way, Hillary Clinton said she would demand of her nominee something you have rightly said that this administration has not demanded of you, which is a commitment on any case as to how you will rule. Democrats have shown no compunction in expecting their nominees to make a promise. Here's how I'm going to vote on a pending case. Judicial ethics be damned. Or how about the Second Amendment? We've heard some reference to the Heller decision. Senator from Connecticut yesterday talked about reasonable gun control and gun safety provisions. Well, that, of course, was not what was at stake in the Heller decision. Number one, majority decision in Heller, Justice Scalia's opinion, acknowledges reasonable provisions, things like prohibitions on felons in possession are permissible. Your opinion in the Cantor decision likewise acknowledged that restrictions preventing dangerous criminals from receiving firearms are entirely consistent and permissible under the Second Amendment. But the issue at Heller was much more fundamental. It was whether the Second Amendment protects an individual right to keep and bear arms at all. The vote in Heller was 5-4. By a vote of 5-4, the majority struck down the District of Columbia's total prohibitions on owning an operative firearm in the District of Columbia. The argument of the 4 dissenters was not what our Democratic colleagues talk about here. It wasn't some reasonable gun control provisions are okay. That was not the argument of the dissenters. That question we can actually have a reasonable debate on. Reasonable minds can differ on what the appropriate line should be, what are reasonable laws there, but that was not what was at issue at Heller. The position of the 4 dissenters was the Second Amendment protects no individual right to keep and bear arms whatsoever, but merely a, quote, collective right of the militia, which is fancy lawyer talk for a non-existent right. 4 justices would have ruled that way, 1 vote away. The consequences of the court concluding that there is no individual right under the First Amendment would mean you and I and every American watching this would lose your Second Amendment right. It would mean the federal government, the state government, the city could ban guns entirely, could make it a criminal offense for any one of us to own a firearm. And no individual American would have any judicially cognizable right to challenge that. That is a radical reading of the Constitution. That is effectively erasing the Second Amendment from the Bill of Rights. And Hillary Clinton likewise promised in 2016 that every justice she nominated would commit to voting to overturn Heller. They were big on litmus tests. And Joe Biden, although he refuses to answer just about anything about whether or not he's going to pack the court, he did tell the American people the voters don't deserve to know whether he's going to pack the court. Truly a statement of disrespect and contempt for the voters, unusual in our political process. 1 vote away from the Second Amendment being erased from the Bill of Rights. None of our Democratic colleagues admit that that is their agenda, and yet those are the justices that Democratic presidential nominees are promising they will appoint. Justices who will take away your right to criticize politicians, justices who will allow censorship, justices who will allow movies and books to be banned, justices who will erase the Second Amendment from the Bill of Rights. And how about religious liberty? Religious liberty is an issue near and dear to a great many of us. The right of every American to live according to your faith, according to your conscience, whatever that faith may be. Religious liberty is fundamentally about diversity. It's about respecting diversity, that whatever your faith tradition might be, the government is not going to trample on it. Religious liberty cases over and over again have been decided 5-4. The case of Van Orden versus Perry, a case I litigated. dealt with the Ten Commandments monument that stands on the state capitol grounds. It's been there since 1961 in Texas. An individual plaintiff, an atheist, a homeless man, filed a lawsuit seeking to tear down the Ten Commandments. The case went all the way to the U.S. Supreme Court. It was decided 5-4. 4 justices were willing to say, in effect, send in the bulldozers and tear down that monument because you can't gaze on the image of the Ten Commandments on public land. Another case, the Mojave Desert Veterans Memorial. This is a memorial erected to the men and women who gave their lives in World War I. It's a lone white Latin cross, simple and bare in the middle of the desert. I've been there on Sunrise Rock where it stands. The ACLU filed a lawsuit saying you cannot gaze on the image of a cross on public land, and the ACLU won in the district court. They won in the Ninth Circuit Court of Appeals. The federal courts ordered that Veterans Memorial to be covered up with a burlap sack with a chain on the bottom, and then a plywood box. When the case went to the U.S. Supreme Court, I represented 3 million veterans pro bono for free, defending that Veterans Memorial. We won 5-4, and there were 4 justices prepared to say, tear down the Veterans Memorial, and under the reasoning that they put forth, they were not far away from saying, bring out the chisels and remove the crosses and the stars of David on the tombstones of the men and women that gave their lives at Arlington Cemetery defending this nation. That is a radical view, and we're 1 vote away. That is utterly contrary to the text of the First Amendment, to the understanding of the First Amendment. When we argued the Ten Commandments case in the U.S. Supreme Court, there was more than a little bit of irony. In that, do you know how many times the image of the Ten Commandments appears in the courtroom of the Supreme Court? The answer to that is 43. There are 2 images of the Ten Commandments carved on the wooden doors as you walk out of the courtroom. You will soon be sitting looking at them. There are 40 images of the Ten Commandments on the bronze gates on both sides of the courtroom. And then, Judge Barrett, when you're sitting at the bench, above your left shoulder will be a frieze you know well, a frieze carved into the wall of great lawgivers, one of whom is Moses. He is standing there holding the Ten Commandments, the text of which is legible in Hebrew, as he looks down upon the justices, and 4 justices were willing to say, in effect, bring out the sandblasters, because we must remove God from the public square. That is a profound threat to our religious liberty, and I would note that it doesn't just extend to public acknowledgments. It also extends to religious liberty. The Little Sisters of the Poor, our Catholic convent of nuns who take oaths of poverty, who devote their lives to caring for the sick, caring for the needy, caring for the elderly. And the Obama administration litigated against the Little Sisters of the Poor, seeking to fine them in order to force them to pay for abortion-inducing drugs, among others. It's truly a stunning situation when you have the federal government litigating against nuns. The Supreme Court decided the Hobby Lobby case, another case routinely denounced by Senate Democrats. The Hobby Lobby case concluded that the federal government could not permissibly force a Christian business to violate their faith. It reflected the religious liberty traditions of our country, that you can live according to your faith without the government trampling on it. You know what this body did, I'm sorry to say? Senate Democrats introduced legislation to gut the Religious Freedom Restoration Act. Religious Freedom Restoration Act, when it passed this body, passed with an overwhelming bipartisan majority. Senate Democrats, including Chuck Schumer and Joe Biden and Ted Kennedy, all voted for the Religious Freedom Restoration Act. Democratic President Bill Clinton signed the Religious Freedom Restoration Act. And yet, in the wake of the Hobby Lobby decision, this body voted on legislation to just gut the protections for religious liberty. And I'm sorry to say, every single Senate Democrat voted to do so. Not a single one, zero, would defend religious liberty. Joe Biden has already pledged, if he's elected, he plans to initiate again the attack on the Little Sisters of the Poor. You know, it's interesting, folks in the press like to talk about Pope Francis. And on some issues, Pope Francis has been vocal when it comes to the environment, when it comes to issues concerning immigration. The Pope has been vocal on issues that our Democratic colleagues like and agree with. The press is happy to amplify those views. Somehow missing from that amplification is acknowledgement that when the Pope came to the United States in Washington, he went and visited the Little Sisters of the Poor. Here in D.C., he went to their home here in D.C., and the Vatican explained he did so because he wanted to highlight their cause. That the federal government shouldn't be persecuting nuns for living according to their faith. That's what's at stake in these nominations. And you won't hear any of that from the Senate Democrats on this committee. That's why their base is so angry at your nomination, Judge Barrett, because they don't believe you are going to join the radical efforts to erase those fundamental rights from the Bill of Rights. I believe that issue, preserving the Constitution, preserving the Bill of Rights, our fundamental liberties, I believe is the most important issue facing the country in the November elections. And I think for those of us who value those rights, we should take solace in the fact that not a single Democrat is willing even to acknowledge the radical sweep of their agenda, much less defend it. They know it's wildly unpopular, and look, right at the heart of this is a decision many Democrats have made to abandon democracy. You see, most policies like Obamacare, policies like health care, most policies under our constitutional system are meant to be decided by democratically elected legislatures. Why? So they can be accountable to the people. So if the voters disagree, they can throw the bums out. But too many Democrats have decided today that democracy is too complicated. It's too hard to actually convince your fellow Americans of the merits of your position. It's much easier just to give it to the courts. Find 5 lawyers in black robes and let them decree the policy outcome you want, which makes your radical base happy, presumably makes the millions, if not billions, in dark money being spent for Democrats happy, without actually having to justify it to the American people. Judge Barrett, I'm not going to ask you to respond to any of that. But I do want to shift to a different topic, which is a bit more about you personally, your background. Judge Barrett, do you speak any foreign languages?
Once upon a time, I could speak French, but I have fallen woefully out of practice, so please don't ask me to do that right now.
You can be assured of that, because I had 2 years of high school French, and I suspect yours remains much better than mine. How about music? Do you play any instruments?
The piano.
Do you? How long have you played the piano?
Well, I played the piano growing up for 10 years, and now most of my piano playing consists of playing my children's songs for them and supervising their own piano practice. I look forward one day when I have more time to be able to choose some of my own music.
Now, do the kids do piano lessons as well?
The kids do piano lessons. Some of the older ones who are in high school have gotten so busy with sports and those things that they've stopped, but the younger children do.
Our girls are 9 and 12, and they both do piano lessons, and I will say, at least in our household, it is less than voluntary. One of the things Heidi and I found, particularly the last 6 months during COVID, which has been an extraordinary crisis, is just with 2 kids at home, that doing distance learning when schools were shut down was really hard for us with 2 children. For you and your husband, you've got 7 kids. How did y'all manage through the lockdowns and distance learning? What was that like in the Barrett household?
Well, it was a challenging time, as it was for every American. Our oldest daughter, Emma, who's in college, moved home at that point because she's at Notre Dame. It closed. So Emma obviously could manage her own e-learning, and our high school age children, Tess and Vivian, could too. But Jesse and I just tried to take a divide and conquer approach for the younger 4. And yeah, it was quite challenging, I assure you.
One part of your story that I find particularly remarkable and that I admire is the decision you made to adopt 2 children. You and your husband had 5 biological children, and you adopted 2 more. Both of your adopted children are from Haiti. Haiti is a country that has some of the most crushing poverty in the world. My brother-in-law is a missionary in Haiti, and actually Heidi and the girls just got back from Haiti a couple of weeks ago. I was curious if you would share with this committee and with the American people what led you and your husband to make the decision to adopt. It's I think, one of the most loving and compassionate decisions any family can make.
When Jesse and I were engaged, we met another couple who had adopted, in this instance, it was a couple who had adopted a child with special needs. And then we also met another couple who had adopted a few children internationally. And we decided at that point, while we were engaged, that at some point in the future, we wanted to do that ourselves. And I guess we had imagined initially that we would have whatever biological kids that we had decided to have and then adopt at the end. But after we had our first daughter, Emma, we thought, well, why wait? So I was expecting Tess when we went and got Vivian. So she and Tess function, we call them our fraternal twins. They're in the same grade. And it really has enriched our family immeasurably. And you know, once we had adopted Vivian, at that point, then we made the decision that we definitely wanted to adopt again. And so several years later, John Peter entered our family.
So your children have been wonderfully well behaved. I think you're an amazing role model for little girls. What advice would you give little girls?
Well, what I'm saying is not designed, my brother now has left, I was just thinking of what my dad told me before the spelling bee about anything boys can do, girls can do better. And since my sons are sitting behind me, I will also say, but boys are great too.
Thank you.
Thank you. Senator Klobuchar.
Thank you very much, Mr. Chair. Welcome again, Judge. Since I have the draw to always follow Senator Cruz, I did want to make one thing clear after listening to that for a half hour, that Joe Biden is Catholic and he is a man of faith. And then I want to turn to something else, and that is that we need a reset here, in my mind, for the people at home, a bit of a reality check that this isn't normal right now. We have to understand that what people are dealing with, that 7.7 million people have gotten this virus, that 214,000 Americans have died. And for people watching at home and wondering what we're all doing in this room right now, and maybe you're home because you lost your job, or maybe you got your kids crawling all over your couch right now. Maybe you're trying to teach your first grader how to do a mute button to go to school. Or maybe you've got a small business that you had to close down or that's struggling. We should be doing something else right now. We shouldn't be doing this. We should be passing coronavirus relief like the House just did, which was a significant bill that would have been a big help. And I think people have to know that right now. And whether you're Democrat, Independent, or Republican. And that's why I started out yesterday by telling people that they need to vote. Number two, some of my colleagues throughout this hearing on the other side have been kind of portraying the job that the judge is before us on as being some kind of ivory tower exercise. I think one of my friends called it related that you'd be dealing with the Dormant Commerce Clause. Well, I'm sure that might be true, but we also know that this is the highest court in the land, that the decisions of this court have a real impact on people. And I appreciated, Judge, that you said that you didn't want to be a queen. I actually wouldn't mind being a queen around here, if the truth be known. I wouldn't mind doing it, and kind of a benevolent queen and making decisions so we could get things done. But you said you wouldn't let your views influence you and the like, but the truth is the Supreme Court rulings, they rule people's lives. They decide if people can get married. They decide what schools they can go to. They decide if they could even have access to contraception. All of these things matter. So I want to make that clear. And the third reset here that I think we need to have is that this hearing is not normal. It is a sham. It is a rush to put in a justice. The last time that we had a vacancy so close to an election was when Abraham Lincoln was president. And he made the wise decision to wait until after the election. The last time we lost a justice so close to an election. That's what he did. Today, we are 21 days from the election. People are voting. Millions of people have already cast their ballots. And I go to the words of Senator McConnell. The last time we had a situation in election year, he said, the American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. That set the precedent that so many of you have embraced, or at least you did a few years ago, and that is that in an election year, the people choose the president, and then the president nominates the justice. So why is this happening? Well, that's a good question. This guy, our president, he is the one that decided to plop a Supreme Court nomination in the middle of an election when people's health care is on the line with a case before the court on November 10th. So let's see what he said about the Supreme Court. Well, one of President Trump's campaign promises in 2015 was that his judicial appointments will do the right thing on Obamacare. You can see it right here. And in fact, Judge, just one day after you were nominated, this is like a few weeks ago, he said also on Twitter that it would be a big win if the Supreme Court strikes down the health law. So, Judge, my first question, do you think we should take the president at his word when he says his nominee will do the right thing and overturn the Affordable Care Act?
Senator Klobuchar, I can't really speak to what the president has said on Twitter. He hasn't said any of that to me. And what I can tell you, as I have told your colleagues earlier today, is that no one has elicited from me any commitment in a case or even brought up a commitment in the case. I am 100% committed to judicial independence from political pressure. So whatever people's, party platforms may be or campaign promises may be, the reason why judges have life tenure is to insulate them from those pressures. So I take my oath seriously to follow the law, and I have not pre-committed, nor would I pre-commit to decide a case any particular way.
Okay, and I think this life tenure, this idea that you have, just for everyone out there, a job for life, makes this even more important for us to consider where you might be. And I know you have not said how you would rule on this case that's coming up right after the election, where the president had said it would be a big win if the Supreme Court strikes down the law. But you have directly criticized Justice Roberts in an article in my own state in one of the Minnesota Law School journals. It was in 2017. It was the same year you became a judge. And when Roberts writes the opinion to uphold the Affordable Care Act, you said he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute. Is that correct?
Senator Klobuchar, I just want to clarify, is this the constitutional commentary publication that you and I discussed?
Yes,
'Cause
it
I haven't
is.
done that.
That
Okay.
it is, but it's still a
No,
University of Minnesota law. Yes.
Okay, I just wanted to be sure because
Yep,
I hadn't published in the
I
Minnesota
just,
Law Review.
again, did you ask that question? Did you say that he pushed the Affordable Care Act beyond its plausible meaning to save the statute?
One thing I want to clarify is you said that I criticized, Chief Justice Roberts, and I don't attack people, just ideas. So that was
Okay.
just designed to make a comment about his reasoning in that case, which as I've said before, is consistent with the way the majority opinion characterized it as the less plausible reading of the statute.
Okay, so you didn't agree with his reasoning in the case that upheld the Affordable Care Act?
What I said, and was this King versus Burwell or NFIB versus Sebelius?
That was NFIB versus Sebelius.
Sebelius.
I'll get to King versus Burwell in a second.
Okay. What I said with respect to NFIB versus Sebelius is that the interpretation that the majority adopted, construing the mandate to be a tax rather than a penalty, was not the most natural reading of the statute.
But
I
it was
made no
still the
comment.
reading that Justice Roberts got to. Now, you also criticized, as you pointed out by bringing up King v. Burwell, another case where the court ruled in favor of the health law. This was in a 2015 National Public Radio interview. And you acknowledged that the result of people being able to keep their subsidies under the Affordable Care Act would help millions of Americans. Yet you praised the dissent by Justice Scalia, saying the dissent had, quote, the better of the legal argument. Is that correct?
I did say that, yes.
Okay, so then would you have ruled the same way and voted with Justice Scalia?
Well, Senator Klobuchar, one of the plus sides or the upsides of being an academic is that you can speak for yourself, that a professor professes and can opine, but it's very different than the judicial decision-making process. So it's difficult for me to say how I would have decided that case if I had to go through the whole process of judicial decision-making that I was describing this morning. Now, having been a judge for 3 years, I can say I appreciate greatly the distinctions between academic writing or academic speaking and judicial decision-making, such that a judge might look at an academic and say, easy for you to say, because you're not on a multi-member court, you're not constrained by stare decisis, you don't have real parties in front of you, consulting with litigants, consulting with your clerks.
Yes.
It's just a different process.
I viewed this one so interestingly because you were commenting on the public policy result, which you and my colleagues on the Republican side have said this shouldn't be about public policy, and you said, okay, that's okay, but then you were really clear on your legal outcome in terms of your view of whose side you were on. You were on Scalia's side, and of course, that was a side to not uphold the Affordable Care Act, which would have been kicked millions of people off their health care in effect because they would have lost their subsidies. And I just see this as interesting because of this kind of dichotomy they're trying to make between policy and legal. And my view is that legal decisions affect policy. I mean, I'm looking at people in my state that'll deal with this if the Affordable Care Act is struck down. Elijah from St. Paul, who was born with cerebral palsy. Because of the Affordable Care Act, he is now 16 and is a proud Boy Scout. Casey, whose brother lives in Alexandria, and he has chronic kidney failure, and he needs a transplant. Without the ACA, that'd be that. Or Burnett from the suburbs of St. Paul, whose daughter has multiple sclerosis, depends on benefits under the ACA. Liliana of Fridley, who has a 21-year-old son with autism and needs her children to be able to stay on her insurance until she's 26. Melanie, a senior from Duluth, who's being treated for ovarian cancer and needs access to the Affordable Care Act. So my point is that these are real-world situations. And so I get that you're not saying how you'd rule on these cases. So what does that leave us with here to try to figure out what kind of judge you would be? And I was thinking last night of when I was growing up, we would go up to northern Minnesota, and we didn't have a cabin, but we had friends that did, and we would go on these walks in the woods with my mom, and she loved to show all the tracks on that path, whether they were deer tracks, and she'd have us figure out what they were, or elk, or maybe even a bear. And we would follow these tracks down that path. And you'd always think, is there going to be a deer around the corner that we're going to see? And very rarely was there one. But we would follow the tracks. And so when I look at your record, I just keep following the tracks. That's what I've got to do. And so when I follow the tracks, this is what I see. You consider Justice Scalia, one of the most conservative judges in the history of the Supreme Court, as your mentor. You criticize the decision written by Justice Roberts upholding the Affordable Care Act. That is, to me, one big track. Even if you didn't consider yourself criticizing him personally, you criticized the reasoning. You then said in another case about the Affordable Care Act that you liked the legal reasoning, that he had the better legal argument, that Justice Scalia had the better legal argument. You have signed your name to a public statement featured in an ad, a paid ad, that called for an end to what the ad called the barbaric legacy of Roe v. Wade, which ran on the anniversary of the 1973 Supreme Court decision. You disagreed with long-standing precedent on gun safety, which said that felons shouldn't be able to get guns, something that was pretty important to me when I had my old job in law enforcement. This is something that Senator Durbin asked you about. You suggested that you agree with the dissent in the marriage equality case, Obergefell, that it wasn't the role of the court to decide that same-sex couples had the right to be married. I think this was in a lecture you gave where you said the dissent's view was that it wasn't for the court to decide. People could lobby in state legislatures. And all this takes me to one point as I follow those tracks down that path. And it takes me to this point where I believe, and I think the American people have to understand, that you would be the polar opposite of Justice Ginsburg. She and Justice Scalia were friends, yes, but she never embraced his legal philosophy. So that is what concerns me. And I want to turn to an area where I think Justice Ginsburg, whose seat we are considering you for, was truly a hero, and that was the area of voting rights. And that was the area of elections. I think that, what did the president say here? He said, September 23rd, 2020, I think this, he means the election, will end up in the Supreme Court. And I think it's very important that we have 9 justices. I don't think how much clearer we can be. And as I said yesterday, I do not for a minute concede that this election is going to end up in the Supreme Court, because people are voting in droves as we speak. But that is what is on the mind of the man who nominated you for this job. Then he said, on September 29th of 2020, I think I'm counting on them, he meant the court, to look at the ballots definitely. So, I know you said earlier in questions from Senator Leahy that you are not going to commit to whether or not you are going to recuse yourself for any kind of an election case. But I do want to point out that as the president has said these things, and as he has nominated you, that people are voting right now. They are voting, as I said, in droves. Do you know how many states or people are voting right now, Judge? I think one of my colleagues said it earlier.
I don't know.
It's more than 40 states. People are voting right now as we speak. I think something like 9 million votes have been cast. Do you think it is faithful to our democratic principles to fill a Supreme Court vacancy this close to an election when people are still voting?
Senator Klobuchar, I think that is a question for the political branches.
Okay. That's your right to answer in that way. Beyond this immediate election, I want to turn to the Supreme Court's critical role when it comes to the right to vote, this area where Justice Ginsburg was such a champion. Senator Durbin went over your dissent at length in Cantor v. Barr, where you drew a distinction between individual rights and civic rights. And you wrote that historically, felons should be disqualified from exercising certain rights, like the right to vote and to serve on juries. So my question is this next line where you said, these rights belonged only to virtuous citizens. What does that mean?
Senator, I would need to look at the article to clarify, but as I'm sitting here, I don't think I said felons should lose voting rights. I think what I was talking about is that
Could.
14th Amendment, yeah, that.
But it wasn't an article, just to be clear, right? This is your dissent.
Oh, my dissent.
Yeah, I think it's your dissent in Cantor v.
Yes, you're right.
And it says felons could be disqualified from exercising certain rights, like the rights to vote and serve on juries. But apart from that clause, you said these rights belong only to virtuous citizens. That's what I'm trying to understand what that means.
So the argument in the case, those who were challenging Heller and those who were arguing on the side of the government in the Cantor case is that the Second Amendment is a civic right. And that is how the Supreme Court itself framed the debate, as a distinction between civic rights and individual rights, with voting being a civic right. And in literature, in the historical literature, which was at play in that case.
Okay, but how would you define the word virtuous? Because it doesn't appear in the Constitution.
Well,
I'm
Senator,
just trying to know what that means, because we're living at a time where a lot of people are having their voting rights taken away from them. So what's virtuous?
Okay, well, Senator, I want to be clear that that is not, in the opinion, designed to denigrate the right to vote, which is fundamental. The distinction between civic and individual rights is one that's present in the court's decisions, and it has to do with a kind of a jurisprudential view of what rights are. And the virtuous citizenry idea is a historical and jurisprudential one. It certainly does not mean that I think that anybody gets a measure of virtue and whether they're good or not and whether they're allowed to vote. That's not what I said.
Okay, now let me ask you this in a different way, because now let's go to the real world here. So in Justice Ginsburg's dissent in Shelby, where a 5-4 court struck down a key provision of the Voting Rights Act, she described the right to vote as a fundamental right in our democratic system. And I assume you agree with this, because you just said that, let's not get to her dissent. You agree with the concept that it's a fundamental right, because you just
As I just said, yeah, the court has repeatedly said it was
Okay,
fundamental.
so she also wrote in her dissent that the Constitution uses the words right to vote in 5 separate places, the 14th, 15th, 19th, 24th, and 26th Amendments. Each of these amendments, this is still her talking, not me, each of these amendments contains the same broad empowerment of Congress to enact appropriate legislation to enforce the protected right. The implication is unmistakable. Under our constitutional structure, Congress holds the lead rein in making the right to vote equally real for all U.S. citizens. Do you agree with Justice Ginsburg's conclusion that the Constitution clearly empowers Congress to protect the right to vote?
Well, Senator, that would be eliciting an opinion from me on whether the dissent or the majority was right in Shelby County, and I can't express a view on that, as I've said, because it would be inconsistent with the judicial rule.
Okay, so here's my problem. So you go out of your way in the case that Dick Durbin was discussing to make this distinction between voting rights and gun rights, but now you won't say whether or not you agree with Ginsburg. And so my view is, just based, again, following those tracks on this case, that you are most likely with the majority, but I know you're not going to answer this. But what I do want you to know is this, and this is where it gets interesting because of what Justice Ginsburg predicted in that dissent. According to the Brennan Center, over 20 states since that case came out that withdrew, that took away part of the protections from the Voting Rights Act, over 20 states have now made more restrictive voting laws than they did before that case. Doesn't that suggest to you that Justice Ginsburg had the better of the argument when she wrote that throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet? Do you think that that's true? And, I mean, it seems to me that the proof is in the pudding. Like, basically, this rainstorm that she said would come has come with all these states, including a number of them that my colleagues over there represent, have enacted stricter laws. Has it happened?
Senator Klobuchar, I want to clarify, you said I was answering Senator Durbin's questions about the Second Amendment, but refusing to answer yours. And so I just wanted to clarify that I had written Cantor versus Barr, and so that's why I was talking about it. But since I didn't write Shelby, I can't really talk about it. So anything that I've written about or talked about, I would be happy to answer your questions.
Okay. All right. But again, it just seems to me you are out of your way on that case. And this is a case that is so real for so many people right now. And that while you can say it's a fundamental right, the issue is that this case and the Voting Rights Act are so key. And let me just say why. We're talking about the entire foundation of our democracy here. For centuries, Americans have fought and died to protect the right to vote. And so what matters is not just what you say about its being fundamental, it's what you do. States like South Carolina, Texas, North Carolina, Louisiana, Tennessee have policies that make it harder for people to vote. And it's a real-world thing before the Supreme Court. In fact, back in May, when voters in Wisconsin were standing in line in the middle of a pandemic, in homemade masks, in garbage bags, in the middle of a rainstorm, just to exercise their right to vote, 70 of them got COVID, because we didn't know enough about it back then, because the president hadn't told us what he knew, and we didn't know enough to protect those voters. So it ends up at the Supreme Court. What did Justice Ginsburg do? When the Republican-appointed majority on the court ruled that voters in Wisconsin could not have more time to get their ballots in during the pandemic, she called them out in her dissent, in her blueprint for the future, and she said the majority opinion boggled the mind. So what boggles my mind? Well, 2 weeks ago, the U.S. Supreme Court reinstated the South Carolina requirement that mail-in ballots must have witness signatures. In the middle of a pandemic, you got to go and get a witness. In Texas, Republicans have argued that the pandemic wasn't a good enough reason to let people under age 65 vote by mail, despite the fact that over 42,000 Americans under 65 have died from COVID. And the governor right now is forcing that state to have only one ballot box per county, including in Harris County, where there are 4.7 million people. And for those of you that thought a judge took care of it a few days ago, he did. But then yesterday, 3 Trump-appointed judges came in and reversed that. So we're back to one ballot box for people to drop their ballots off in a county of 4.7 million people. In Tennessee, Republicans have tried to prevent ballot drop boxes. I know we had the Secretary of State as one of our witnesses at a Rules Committee hearing, and they have argued in court that COVID-19 is not a valid excuse to vote by mail. In North Carolina, the Supreme Court struck down a core component of the Voting Rights Act. What happened? Well, states like North Carolina passed laws that were so egregious to make it harder to vote that the Fourth Circuit struck down their law and noted that it targeted African Americans with almost surgical precision. So that is what the stakes are. And that is why not having Justice Ginsburg on the court right now is so frightening to so many Americans out there. And that is why we are asking you these questions about voting. So let me turn to another election question, gerrymandering. In 2015, Justice Ginsburg wrote the majority opinion in Arizona State Legislature for the Arizona Independent Redistricting Commission, holding that it was constitutional for the people of Arizona to amend the state constitution to establish an independent redistricting commission. Because of this case and Justice Ginsburg's opinion, many argue now that Arizona has fairer electoral maps. The decision was 5-4. Here's your example. And now Justice Ginsburg and Justice Kennedy are no longer on the court. My question is this: must state legislatures abide by their own state's constitution when exercising their authority under the Elections Clause?
Senator Klobuchar, that would be eliciting an opinion from me about whether I agreed or disagreed with the result in that case.
Okay,
And
is it
constrained from doing that.
constitutional for voters to amend a state constitution to establish specific processes for elections, like the voters in Arizona did to stop gerrymandering?
Again, you're asking me for a view on that particular case, and Justice Ginsburg herself gave the most famous articulation of the principle that constrains me from doing so, which is no hints, forecasts, or previews. So I can't express a view on precedent or on how I would decide any question that was provoked by the application of that precedent to a later case.
Okay, last week a contractor from outside of my state of Minnesota started recruiting poll watchers with special forces experience to protect polling locations in my state. This was clear voter intimidation. Similar efforts are going on around the country, solicited by President Trump's false claims of massive voter fraud, something that, by the way, many Republican leaders, including Michael Steele, the former head of the Republican Party, including Tom Ridge, including Governor Kasich, including sitting Senator Romney, have made very clear is not true. So as a result of his claims, people are trying to get poll watchers, special forces people, to go to the polls. Judge Barrett, under federal law, is it illegal to intimidate voters at the polls?
Senator Klobuchar, I can't characterize the facts in a hypothetical situation, and I can't apply the law to a hypothetical set of facts. I can only decide cases as they come to me, litigated by parties on a full record after fully engaging precedent, talking to colleagues, writing an opinion. And so I can't answer questions like that.
Okay, well, I'll make it easier. 18 U.S.C. 594 outlaws anyone who intimidates, threatens, coerces, or attempts to intimidate, threaten, or coerce any other person for the purpose of interfering with the right of such other person to vote. This is a law that has been on the books for decades. Do you think a reasonable person would feel intimidated by the presence of armed civilian groups at the polls?
Senator Klobuchar, that is eliciting, I'm not sure whether to say it's eliciting a legal opinion from me, because the reasonable person standard, as you know, is one common in the law, or just an opinion as a citizen, but it's not something really that's appropriate for me to comment on.
Okay. Here's one that I think is selection of electoral college electors. You know that each state has laws that dictate how electoral college electors are selected. Judge Barrett, in 1932, the Supreme Court in Smiley v. Home, a case involving my state, ruled that the Minnesota State Legislature could not change election rules unilaterally. Do you agree that the unanimous opinion in Smiley v. Home, which has never been questioned by any other Supreme Court case, is settled law?
Well, I'll say two things about that. First of all, I was not aware of that case, so you've taught me something.
Okay.
But secondly, I can't comment on the precedent, give thumbs up or thumbs down in Justice Kagan's words.
Okay, well, why don't we end there with precedent? I think that's a good way to end here. So you wrote in your 2013 Texas Law Review article that you tend to agree with the view that when a justice's best understanding of the Constitution conflicts with Supreme Court precedent or case law, it is, quote, more legitimate for her to follow her preferred view rather than apply the precedent. And I want to run through a few examples. So Brown v. Board of Education, as we know, that holds that the 14th Amendment prohibits states from segregating schools on the basis of race. So is that precedent
Yes.
that can't be overruled?
Well, that is precedent. And as I think I said in that same article, it's super precedent. People consider it to be on that very small list of things that are so widely established and agreed upon by everyone. Calls for its overruling simply don't exist.
Okay. Well, you also separately acknowledged that in Planned Parenthood v. Casey, the Supreme Court's controlling opinion talked about the reliance interests on Roe v. Wade, which it treated in that case as super precedent. Is Roe a super precedent?
How would you define super precedent?
I might thought someday I'd be sitting in that chair. I'm not, I'm up here, so I'm asking you.
Okay, well,
So-
people use super precedent differently.
Okay,
The way that it's used in the scholarship and the way that I was using it in the article that you're reading from was to define cases that are so well settled that no political actors and no people seriously push for their overruling. And I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall in that category. And scholars across the spectrum say that doesn't mean that Roe should be overruled, but descriptively, it does mean that it's not a case that everyone has accepted and doesn't call for its overruling. I don't
okay,
think
so here's what's interesting to me. You said that Brown is, and I know my time is running out, is a super precedent. That's something the Supreme Court has not even said, but you have said that. So if you say that, why won't you say that about Roe v. Wade, a case that the court's controlling opinion in that Planned Parenthood v. Casey case has described as a super precedent? That's what I'm trying to figure out.
Well, Senator, I can just give you the same answer that I just did. I'm using a term in that article that is from the scholarly literature. It's actually one that was developed by scholars who are, you know, certainly not conservative scholars, who take a more progressive approach to the Constitution. And again, you know, as Richard Fallon from Harvard said, Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
Is United States v. Virginia military, is that super precedent?
Senator Klobuchar, if you continue to ask questions about super precedents that aren't on the list of the super precedents that I discussed in the article that are well acknowledged in the constitutional law literature, every time you ask the question, I will have to say that I can't grade it.
Okay. Well, I am then left with looking at the tracks of your record and where it leads the American people. And I think it leads us to a place that's going to have severe repercussions for them. Thank you.
Senator Sass.
Thank you, Mr. Chairman. Judge, welcome back. I mean this as good news, but it might not feel like it after me. You're half done for today. I'm 11th of 22. Mr. Chairman, before I begin my questioning, I'd like to ask unanimous consent to admit into the record a letter from Alan Gelzo, the historian at Princeton, who has written a letter to the committee in response to some of Senator Harris's claims about the history of Supreme Court vacancies going back to the Civil War.
Without objection.
Thank you. Judge, you have said that the meaning of law doesn't change with time, and you've said that's very important. Can you unpack for us why it's so important that the meaning of a law doesn't change with time?
Sure, because the law stays the same until it is lawfully changed. And if we're talking about a law that has been enacted by the people's representatives, you know, or gone through the process of constitutional amendment or constitutional ratification, it must go through the lawfully prescribed process before it's changed. So Article 5 in the context of the Constitution, or bicameralism and presentment in the context of statutes. And it's not up to judges to short-circuit that process by updating the law. That's your job.
But laws clearly are written in a context, and then the things, the circumstances to which those laws have applied would change. Does the Fourth Amendment have nothing to say about cell phones? Unreasonable search and seizure was obviously not written at a time when they had imagined mobile technological devices that addicted our kids. Does the Fourth Amendment have nothing to say about cell phones?
No, the Fourth Amendment, so the Constitution, one reason why it's the longest lasting written Constitution in the world is because it's written at a level of generality that's specific enough to protect rights, but general enough to be lasting, so that, you know, when you're talking about the constable banging at your door in, you know, 1791 as a search or seizure, now we can apply it, as the court did in Carpenter versus the United States, to cell phones. So the Fourth Amendment is a principle. You know, it protects against unreasonable searches and seizures, but it doesn't catalog the instances in which an unreasonable search or seizure could take place. So you take that principle and then you apply it to modern technology, like cell phones, or, you know, what if technological advances enable someone with Superman X-ray vision to simply see in your house? You know, so there's no need to knock on the door and go in. Well, I think that could still be analyzed under the Fourth Amendment.
So I think this is a useful place to explain to the American people again what originalism is and why it's a mistake to view it as a Republican position. I think that originalism is a part of a jurisprudential debate. It's not a part of a policy continuum between Republicans and Democrats. I think it's something that is useful for everybody who believes that three branches of government have two that are political and one that is not. So maybe it's useful to just kind of back up and say, when you define yourself as an originalist, what does that mean? And then how is it going to relate to that distinction between the principles that are timeless, but the applications that are clearly going to change by circumstance?
Right. So originalism means that you treat the Constitution as law because it commits these texts to writing. And in interpreting that law, you interpret it in accord with the meaning that people would have understood it to have at the time that it was ratified. And the reason that you do that is because otherwise, well, as I said, the law stays the same until it's lawfully changed. Otherwise, judges would be in the Constitutional Convention business of updating the law rather than allowing the people to take control of that. Now, in the case of the Constitution, as I said with the Fourth Amendment, many of its principles are more general, unreasonable searches and seizures, free speech. Those are things that have to be identified or fleshed out or applied over time. So the fact that there wasn't, the internet or computers or blogs in 1791 doesn't mean that the First Amendment's free speech clause couldn't apply to those things now. It enshrines a principle, and we understand the principle as it was at the time, but then it's capable of being applied to new circumstances.
So when you define yourself as an originalist, what are the other schools of thought that are adjacent to it? And how do you think about the debates among those with other people that are now with you on the Seventh Circuit, for instance?
Sure. Well, Senator Sass, I think one thing that it's worth pointing out is that in the academy, in any event, where I've spent a large portion of my career, originalism is not necessarily a conservative idea. There is a whole school of thought, and so originalists are now a very diverse lot. And there is a school of originalism that's more of a progressive originalism and is very committed to keeping the Constitution's meaning, just interpreting text the way all originalists do, to say that it has the meaning that it had at the time that it was ratified, but they tend to read it at a higher level of generality. So all originalists don't necessarily agree. And in fact, there's an advocacy group called the Constitution Accountability Center, which has routinely filed briefs in the Supreme Court that calls itself, it writes briefs in support of originalism, but taking it from a more progressive standpoint. So I think probably people think, oh, it's only conservatives who are originalists, but actually it's a more widely accepted view than that. I think that if you think about different strains of approaching constitutional text, originalism is one. All judges and justices take account of history and the original meaning. It's just that some weight it differently, whereas originalists would give it dispositive weight when it's discernible. Other approaches to constitutional interpretation may take a more pragmatic view and say in some instances, well, that may have been the historical meaning, but that's an uncomfortable fit for current circumstances, so we will tweak it a little bit to adjust it to fit these circumstances, that situation. Sometimes it's called living constitutionalism, that the Constitution can evolve and change over time. Sometimes it's called like a more pragmatic constitutionalism.
So I want to make sure we establish this fact clearly together, because one of the things that I think is really unhelpful for the American people when they see hearings like this over the last 20 years is there is an assumption that those of us who've advocated for you over the course of the last 3 years must be doing it because we know something about your policy views, and we've seen the beautiful mind conspiracy theory charts, for instance, that this is about specific outcomes that people want. What I want is to have a judge who doesn't want to take away the job of a legislature that's accountable to the people. What I want is to be sure that the two political branches that are accountable to the people because they can hire and fire us are the places where policy decisions are made. So what you're saying is, in the legal academy, there are people who agree with you on originalism as a broad philosophical school, and yet would come out very different places on the outcomes of particular policy decisions.
That is what I'm saying.
So on the Notre Dame law faculty, when you were up for the vacancy on the 7th Circuit 3 years ago, the Notre Dame law faculty, as I understand, the letter that we got from them here, had people unanimously recommend you across the faculty, and I would assume there's a pretty wide view of policy on the Notre Dame law faculty.
There is.
And so people can affirm that you know what the job of a judge is. You have the judicial temperament and modesty and humility about the calling, and they're comfortable with you even though they don't think they might agree with every policy view that you have before you put on your robe.
I hope that is what people think of me, because that's what I've always striven to do, and certainly in my time as a judge. My job, my boss is the rule of law, not imposing my policy preferences.
So can you tell us what the black robe is about? Why do judges in our system wear robes?
Well, judges in our system wear black robes, and they started wearing black robes actually because Chief Justice John Marshall started the practice. In the beginning, justices used to wear colorful robes that identified them with the schools that they graduated from. And John Marshall, at his investiture, decided to wear a simple black robe. And pretty soon the other justices followed suit, and now all judges do it. And I think the black robe shows that justice is blind. We all dress the same. And I think it shows that once we put it on, we are standing united symbolically, speaking in the name of the law, not speaking for ourselves as individuals.
Thank you. You, in your questioning from Chairman Graham this morning, talked a little bit about the process of judicial decision-making, and you started with 4 steps and then added a 5th, and then I think added a 6th. Because it turns out being a reactive branch is really reactive. Can you explain what it means that the judiciary, the Article 3 branch, is reactive?
So Article 3 of the Constitution says that courts can hear cases or controversies. So a judge can't walk in one day and say, I feel like, visiting the question of health care and telling people what I think. We can't even think about the law or how it would apply until litigants bring a real live case with real live parties and a real live dispute before us. And the material that we have to decide that dispute is what comes from you. It's the statutes that you pass. We don't get to come up with the policies and see our wishes become part of the United States Code. So we react to the litigants who bring cases before us, and we apply the laws that you make.
And what are the steps inside those Article 3 courts before it would ever get to a situation where the Supreme Court hears cases? What is unique about the Supreme Court?
So the Supreme Court obviously sits atop the federal hierarchy of the judiciary. And the Supreme Court, so my court now, the 7th Circuit, every time someone loses in the district courts, which are the trial courts, they can appeal. And we take every single appeal that comes. The Supreme Court works differently. The Supreme Court takes cases when it needs to. Most frequently, the reason it takes them is to resolve a division among the courts of appeal or the state Supreme Courts. The Supreme Court gets about 8,000 petitions a year, and they hear about 80 cases a year. So it's discretionary what cases to take.
So it's reactive, it's a reactive branch, and it's after a process where there's a statute, it's been challenged, there are active cases, and then it works its way up to the court. But when the justices decline to take a case, what are they saying? They're saying you don't matter and you don't have a right to appeal? What are they saying to the litigants in a case when they decline to grant cert?
They're not expressing any view on the merits. They're simply saying this isn't a case that we're going to put on our docket for certiorari because the court has obviously limited time and limited resources, and so it selects the cases where it's resolving a division, for example, in the courts or some other question of national importance on which the Supreme Court needs to step in.
There has been a lot of discussion in some of the questioning earlier this morning implicitly about standing. Can you just explain what standing is so that the American people understand it?
Yes. So this dovetails with your question about the judiciary being a reactive branch. So as I said, the Constitution gives the courts, the federal courts, the power only to decide actual live cases and controversies. So not only can we wake up one morning and volunteer our views, because the Constitution prohibits us from giving what are called advisory opinions. We can't just dispense advice or give our views on the law, which is one reason why I'm not able to answer some of the questions being asked today. A litigant can't get us to give an advisory opinion or elicit a view unless the litigant actually has a real case. So you, Senator Sass, couldn't walk into court and file a lawsuit and just ask me to give my advice on whether some particular statute was constitutional. I can only decide that question if there is an actual dispute about it.
You mentioned living constitutionalism a little bit ago. I think Chief Justice Warren had a much broader view of standing than some of the folks that have influenced your thinking and writing. Can you walk us through a little bit of the history of the court's view of standing over the last few decades?
So are you thinking about how broadly, like when a plaintiff has suffered an injury or that's a concrete injury?
Right.
So Senator Sass, if you came into court and you were objecting to a particular statute and you didn't like a particular statute, you would have to actually suffer what's called a concrete injury. So the Supreme Court a few terms ago in a case called Spokio said that a plaintiff lacks a concrete injury if the harm isn't, let's see, to use words the American people might understand, palpable. Like it can't just be a procedural injury or something that didn't actually have real consequence or real effect on the litigant. I think that the dispute about standing, or the difficult thing in deciding questions of standing, and the Spokio opinion lays this out, is deciding when an injury is concrete and courts can hear it, or when that injury is more abstract and designed to elicit an advisory opinion from the court.
You said in your opening comments yesterday that it is not the responsibility of the courts to right every wrong in society. I want to ask you a question about it, but first, can you just remind us what your view is there? Why did you say that?
So I think probably what I was getting at there, although I have to say, Senator Saff, so much has happened since I gave the opening statement yesterday. Courts, because they are reactive, can't reach out to right wrongs that don't come to them in the case, in the situation of a case or controversy. And then even if they come to courts in the situation of a case or controversy that a court can legitimately decide, we're not free to just resolve it like Solomon in the way that we think is wisest. So we are only free to address wrongs and decide cases in accordance with democratically elected law. So the policy making is yours to do, and it is only if you have enacted policies that enable us to right a wrong that we can do so.
So you still said, though, that you view it as some of your responsibility on the Seventh Circuit to right every opinion, every judgment from the standpoint of the losing party. Explain to us why you take that perspective of wanting the losing party to understand the law and the argument.
So I just write the opinion as I would write the opinion. And then after I write the opinion, I read it from the perspective of the losing party, because I want to make sure that, like I said earlier, it's a check on me to make sure that if I try to put my emotions or my preferences on the other side, that I can see that it's been a balance just strictly driven by legal analysis. I also want to make sure that the language in it is very respectful to the party who will ultimately be disappointed. I don't know if is that responsive to?
Yeah, because why I want to ask this is because I'm in my 5th year here, or a little over 5 years, and I'm on my 4th year on this committee, and pretty much you're the 3rd Supreme Court nominee to come before the committee during that time, and we've had dozens of appellate court nominees, and I've been amazed how many times the argument is American people be really, really scared. The person sitting before us obviously hates people and wants sick people to die and not have health care coverage. That's sort of an argument that's routine around here. It's been focus grouped, obviously, as a good way to demonize nominees to the court and hopefully drive outcomes in elections, I guess. I don't understand it. I think it's terribly destructive of the civic health. And yet, I think about it from the standpoint of thoughtful, well-meaning Nebraska Democrats who hear that, and they know I have a different policy view than they might on getting to portability in healthcare so people can keep their health insurance across job and geographic change, because that's actually what's driving uninsurance in America over the last few decades. It's not primarily health status. It's not primarily pre-existing conditions or socioeconomics. The number one driver of uninsurance in American public life is that we change jobs a lot more frequently than we used to. And so I have a different policy solution of how we would get to portability in healthcare than a lot of my Democratic colleagues, but those are policy disputes about a modern economy where people move around a lot, both geographically and in terms of employer-sponsored health insurance relationships. Those contracts are not really the things that a nominee coming before the court is supposed to opine on, because I don't have any idea what your views are on healthcare, but I know that it's not really the job of a judge to reflect on those things. And so I want to be sure that folks who hear this hearing and at the end of the process, they can have trust that you're not a person who really wishes secretly you could be the queen of all healthcare and decide all these issues. And so when you write your opinion, it seems to me that one of the really humble things you're doing is you're saying, in every case that's come before me on the Seventh Circuit, I want to write this opinion from the standpoint of the losing party to understand what was the question before the court today and how did the court rule on that specific narrow thing. Because ultimately, I think you would believe, given your jurisprudential tradition and given your view of judicial modesty and humility and your Scalia mentorship, my guess is there are times when you rule in cases where you go home at night and you take off your robe and you think the outcome is not the outcome you wish had been the case, but it wasn't your job to ultimately decide all policy in American life. It was to decide the specific question before you. And it seems to me the humble, empathetic way that you write those opinions is really important. It should be in the interest of public trust and American people who might listen to a lot of the demagoguery that implies that really you're just secretly a policy actor. It should be pretty comforting to them that, except for probably Justice Breyer, you've written more than, I think, than anybody who's currently on the court. So people can actually know your jurisprudential views and how you're going to approach cases when you get on the court, because you've written a ton. There's a reason why the Notre Dame faculty, regardless of their policy positions, wrote a letter to this committee universally recommending you. There's a reason why year after year on the Notre Dame law faculty, you were Professor of the Year, because students, regardless of their policy views, thought you were really good at explaining what the job of a judge is and what the purpose of Article 3 in our constitutional system is. And as somebody who worries a lot about institutional trust and a lot of the attacks that we see on the court, a lot of the attempts we see in this language about potentially court packing, if we would go to 11 or 13 or 15 or a Venezuelan-style 47-person court over the next couple of election cycles, that undermining, that delegitimizing of the courts should have as its antidote the fact that you have written a ton about what you think the job of a judge is, and people can actually understand it. And I would hope that that's some of what this hearing would try to unpack. I am nearly out of time, and I think the chairman is going to take away my slot. So I want to ask one final thing. Tell us about the Scalia-Ginsburg friendship and the impact that it made on you.
So Justice Scalia famously, when the vacancy came up, I think it was Justice White's seat that Justice Ginsburg filled, but when the vacancy came open during the Clinton administration, Justice Scalia recommended her, even though they had been together on the DC circuit. That's where they got to know each other. And he knew that she had a different jurisprudential approach. And a lot has been said in the weeks since Justice Ginsburg died about that friendship, because I think it speaks so well to both of their characters, that despite the fact that they had such great differences and they could fight with the pen, when they were socializing, when they were outside of the opinion writing world, they had respect and affection for one another. And that's how I've tried to live my life with, I have friends who disagree with me vehemently about all kinds of things. But I think that it is dehumanizing if we reduce people to the political or policy differences that we might have with one another.
Thank you, and congrats on being half done.
Well, for the record, I really enjoy listening to you, Senator Sass. I think you make a lot of sense, and you explained the system very well. You don't have to be a lawyer to understand what the law is all about. I think you get it very much so. Senator Coons.
Thank you, Mr. Chairman. Thank you, Judge Barrett. To you and your family, welcome. I guess I'm on the downside if you're halfway through. If I might just, at my opening, Mr. Chairman, I'll submit 2 letters for the record, if I might. One from the SEIU on behalf of the 2 million members of the Service Employees International Union, and one on behalf of a national constellation of disability rights groups.
Without
both
objection.
expressing concerns. So, Judge Barrett, if I might, the calendar behind me makes clear something about the context that we're in. Because I think folks watching this at home, despite the wonderful efforts that a number of my colleagues have made to make this accessible, may have difficulty understanding exactly why we're here and why under these circumstances and why we keep bringing up the Affordable Care Act. So let me try and walk that through. These aren't normal times, as you well know. Most of us are wearing masks. There are a number of members of this committee and the Senate who've been infected by COVID, as our president has, and that's resulted in the Senate being closed this week and are not being able to proceed. We're in the middle of a pandemic, and we are just 3 weeks from an election, a presidential election in which folks are voting in more than 40 states. Millions of votes have already been cast. And just a week after that election, the Supreme Court's going to hear a case that could take away health care protections from more than half of all Americans. So this is not an abstract academic argument. It's one that will have real life consequences. Destroying the essential protections of the Affordable Care Act, which was enacted just more than a decade ago, would have a real impact on a majority of all Americans. It prevents insurance companies from discriminating against the more than 100 million Americans with pre-existing conditions like diabetes or heart disease. It dramatically expanded Medicaid, and it provides coverage for kids on their parents' insurance up to the age of 26, I should say young adults. And perhaps most importantly, since a lot of what we've been talking about is the legacy of Justice Ginsburg and her lifelong commitment to gender equity, it also prevents insurance companies, the Affordable Care Act does, from discriminating against women just for being women. It may be hard to imagine now, but more than a decade ago, before the ACA, pregnancy was treated as a pre-existing condition, and women were routinely charged more than men just because insurance companies could. So President Trump, he said over and over again that he is determined to repeal the Affordable Care Act, that he is determined to overthrow it. And there's 2 things all of us are waiting for. One is his detailed health plan. The other is his taxes. And I don't expect either one of them in the next 3 weeks. The president tried to do it here in Congress. In fact, I think by one count, my colleagues have voted 70 times to overturn the ACA. And many in this chamber, many members of this committee, members like Senators Cornyn and Lee and others, have filed amicus briefs before the Supreme Court asking for the law to be struck down. So now on the eve of the election, I believe President Trump is making a last gasp attempt to get the Supreme Court to do it for him. He can't do it through the democratic process. He can't do it administratively. He's going to try and do it with one more challenge. And as you well know, Judge, it was upheld 8 years ago in a 5-4 decision where Chief Justice Roberts wrote a critical, decisive piece of the majority opinion. But Justice Scalia, for whom you're clerked, your mentor, whose broad philosophy you embrace, dissented. He thought it was unconstitutional and voted to strike down the entirety of the law. You wrote an article in Constitutional Commentary in 2017 in which you were quite critical of Chief Justice Roberts' decision. And so I want to ask you about that article, not as a matter of debating abstract academic principles, but because I believe the outcome in this case, a week after the election, may hang in the balance. You wrote in that article, and I quote, "In NFIB versus Sebelius, the case that upheld the ACA against a constitutional challenge, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute." I think those are fighting words as an originalist and a textualist. You were referring to Chief Justice Roberts' ruling that the individual mandate in the ACA is constitutional under Congress's taxing powers, a ruling essential to upholding the law and protecting the health care of a majority of Americans. So just if you could do you think the Chief Justice's ruling upholding the ACA was implausible and unsound?
Well, Senator Coons, what I said in that article, which was a book review of someone else's book, was that the statutory interpretation, as I said earlier, as Chief Justice Roberts' own opinion said, was the less natural reading of the mandate, construing it as a tax rather than a penalty, that the statutory interpretation seemed, as you said, stretched beyond its plausible meaning. But NFIB versus Sebelius turned on the constitutional question. That was the statutory interpretation was the threshold question.
Right.
And the constitutional question was not something that I ever opined on. And the case next week, or the case that's coming down the pike in a few weeks, California versus Texas, I wouldn't say they're fighting words from the article that you read from me, because the California versus Texas case involves a very different issue, this issue of severability. And for those to be fighting words, I think you would have to assume that my critique of the reasoning reflects a hostility to the act that would cause me to approach a case involving the ACA with hostility and looking for a way to take it down, to deprive people of their coverage under the ACA because I didn't like it. But I can promise you that that is not my view, it's not my approach to the law. I have no hostility to the ACA or any other law, and that I will faithfully apply the law, and nothing that I've said with respect to the ACA in print in my law review articles actually bears on the severability question, so it's not indicative of how I might approach that question.
Let me go back to what I perhaps too jokingly referred to as fighting words. You're both textualists. You're both from the same general school of constitutional methodology, correct?
You mean Justice Scalia and me?
And Chief Justice Roberts.
I'm not actually sure that Chief Justice Roberts has ever identified himself as a textualist.
So to that point, in this article 3 years ago, you chastised Chief Justice Roberts for not being a textualist. You said he has not proven himself to be a textualist and has been willing to depart from ostensibly clear text. And so you said in this article, and I'm quoting you, "It is illegitimate for the court to distort either the Constitution or a statute to achieve what it deems a preferable result." So this was the sort of outcomes-oriented judicial crafting that has often been sharply criticized by your mentor, Justice Scalia, when criticizing the sort of living constitutionalists. And as I read this, you are saying to Chief Justice Roberts, you're no textualist. You have overreached. You have delivered an implausible conclusion. And frankly, I disagree with your upholding the constitutionality of this statute. That seems to me, again, as a textualist here, a plain reading of your own writing.
Well, Senator Coons, I want to make very, very clear, I think maybe this came up with Senator Klobuchar, that I was not attacking or chastising Chief Justice Roberts at all, for whom I have the greatest respect. I think this passage that you're talking about in this book review and constitutional commentary was maybe a couple paragraphs, maybe even one paragraph at the end, because it was a comment on Randy Barnett's book, and a lot of his book dealt with the NFIB versus Sebelius as an example. So I was responding to that. And the sentence that you read me about it's illegitimate for a court to twist language in pursuit of a policy goal, that is what I think. That's what I was telling Senator Sass. I mean, I don't think it is the job of courts to pursue policy goals that the text that you enact doesn't support.
So to be clear, you're specifically accusing the Chief Justice, or you're chastising might be the better word, the Chief Justice of distorting the statute and of upholding it when it should have been struck down.
No, I'm not. I was not. I said I was not chastising. All I was doing was expressing some, well, I mean, and as I've said several times, it's how the Chief Justice himself characterized it. It's not the most natural reading of that language. And all I was doing
if I might, Your Honor, I don't think the Chief Justice would agree with that characterization. He didn't describe his own opinion as not plausible.
He said less natural, and I thought it was implausible.
But not unsound.
So, Senator Coons, I certainly would not and did not criticize or chastise the Chief Justice or impugn his integrity. It is true that Chief Justice Roberts and Justice Scalia took different approaches to the text in the Affordable Care Act case, which is something that's widely acknowledged.
I'm simply trying to make clear that I think your writing here in 2017 in Constitutional Commentary, yes, the majority of it is a book review about a book that centrally talks about NFIB versus Sebelius and methodological questions. But near the end, you are, I think, unmistakably clear in saying, I disagree with the Chief Justice's ruling upholding the Affordable Care Act, and I deem it unplausible and unsound.
Senator, as an academic, I did express a critique. And you've quoted the language, you've pulled out those few sentences at the end. I guess I'm a little uncertain what it indicates, because as I've said, I have no hostility to the ACA, and if a case came up before me presenting a different question of the ACA, I would approach it with no bias or hostility. I also have said at earlier points in this hearing that the exercise of being a commentator, an academic, is much different than the enterprise of judging. And I didn't have to sit in Chief Justice Roberts' seat or Justice Scalia's seat when NFIB versus Sebelius was decided. So
but you will, if we follow the timeline laid out by my colleagues, you will sit in former Justice Ginsburg's seat. And you will sit as a member of the court deciding a case that is very similar to the previous one, in which the central issue before the court, believe it or not, somehow will be the constitutionality of the mandate that's in some ways been the linchpin of its being upheld previously in NFIB versus Sebelius. That was the sort of key point, was that at the end of the day, there were 5 justices who, for different reasons, concluded that they could uphold it in the case of the Chief Justice as a legitimate exercise of the taxing power. You wrote, and this is the next sentence, that Chief Justice Roberts, if he had treated the payment owed under the mandate as the statute did, as a penalty, he would have had to invalidate it. So I think you're unmistakably criticizing this decision to uphold the Affordable Care Act in a case that will be before you as a newly seated member of the Supreme Court if the majority continues with this race towards your confirmation. It is the nerve center of the case. The entire future of the Affordable Care Act, I think, hinges on this question of whether or not you share a view with the 4 who were in the minority at the time that this is something that cannot be upheld under any plausible reading of the statute. Let me move on, if I might. Judge Barrett, you're not the only person who's criticized Chief Justice Roberts for his decision to uphold the ACA. President Trump criticized him for it sharply and repeatedly. Soon after the NFIB decision first came out in 2012, he tweeted that Justice Roberts turned on his principles with irrational reasoning in order to get loving press. And then later, congratulations to John Roberts for making Americans hate the Supreme Court because of his BS. A few years later, while running for president, then candidate Trump said on Twitter, and I believe my colleague put this up earlier, if I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare. And as recently as just 2 months ago, Vice President Pence described Chief Justice Roberts as, and I'm quoting, a disappointment to conservatives because of the Obamacare decision. In upholding the ACA, the Chief Justice was the one justice appointed by a Republican president who went against the political wishes of the party that appointed him. Why did you choose to single him out for criticism in that constitutional commentary article?
Well, Senator Coons, I was writing about the majority opinion, and Chief Justice Roberts was the author of the opinion. So I was simply discussing what the 5-justice majority adopted as its reasoning. And I'd like to emphasize again that I was not attacking Chief Justice Roberts or impugning his character or anything of that sort. It was an academic critique. And I want to emphasize, just given this line of questions that you're asking, that I am standing before the committee today saying that I have the integrity to act consistently with my oath and apply the law as the law, to approach the ACA and every other statute without bias, and I have not made any commitments or deals or anything like that. I'm not here on a mission to destroy the Affordable Care Act. I'm just here to apply the law and adhere to the rule of law.
And look, I think it is important that folks watching understand that I believe your views are sincere and earnestly held. And I am not trying to suggest that there was some secret deal between you and President Trump. When you told me that when we spoke a week ago, I've had no conversations about these cases with the president or his legal team. I believe you. I think you are a person who earnestly means that. And I do think it's important that you keep repeating that. But we cannot ignore the larger context that sits outside your nomination and this rushed process. I'm sure you have no ill will towards the Chief Justice and meant no disrespect to him as an individual. We've talked repeatedly about the friendship between Justice Scalia and Justice Ginsburg. You know, I was long inspired by the friendship between Senators Biden and Senator McCain, and they fought hammer and tongs, tooth and nail, disagreed with each other on foreign policy day in and day out, but then could still also spend time together with each other's families and respect each other afterwards. And to the point my colleague from Nebraska has made about civics versus politics, it is important for us to try and sustain these institutions that hold us together.
And you and Senator Flake, I think, are another good example of that.
Indeed. As you well know, we came to Notre Dame Law School just over a year ago to talk about working together even across significant differences. But the broader context that Senator Whitehouse went through in detail was, as you are expressing opinions in an academic journal, there is literally an army of lobbyists and lawyers and people, donors and activists who are funneling new judges into our courts. And I have sat here for 4 years and watched a whole procession of judges where, without going on about this too much, you know, a dozen have been deemed unqualified to serve. This is not a comment on you, but the speed and the process and the disrespect for some of the critical traditions of this body in terms of the blue slip and who gets nominated and why has made it harder and harder to see the independence of the judicial branch. And in this piece that you wrote in 2017, you made, I think, your position with regards to the Chief Justice and his opinion clear. Let me, if I could, put up another poster that may make this a little sharper in a way that is the political branches, not the judicial branch. The Supreme Court's going to hear arguments, as I've said, in this case, a week after the election. And most Americans are probably surprised to even hear about it. When I talk to a constituent, Carrie, who has a pre-existing condition, she was surprised this was even in front of the court. She said, I thought that was settled. Carrie owns a small business. She has a daughter she's raising, and before the ACA, she had to spend $800 a month for insurance that she described as junk. Left her afraid of even going to the doctor's office or needing drugs. And because of the ACA, she's been able to get better quality insurance that she can afford. And she's got both type 2 diabetes and high blood pressure. But the ACA guarantees she can't be denied insurance or made to pay higher premiums either because of her gender or because of these pre-existing conditions. She expressed to me astonishment. Many of us are engaged and interested in this because we care about the Constitution, we care about constitutional law, and the ways in which it impacts a majority of all Americans, frankly, all Americans. Help me explain to her, how is it that the Affordable Care Act, settled 8 years ago, is back in front of the Supreme Court?
Well, Senator, I spent some time with Senator Sass talking about how a case winds its way up, and it's because litigants chose to challenge the law again. And, you know, it went through the district court and the Fifth Circuit, and now the Supreme Court has granted certiorari on it and is answering the question. But as to the broader question, which I think is a political one, which is why are people fighting the Affordable Care Act, you have to ask the litigants. I don't know why they're fighting the Affordable Care Act.
Well, two things on that. Yes, there are no advisory opinions, as you said in your exchange with Senator Sass, and you have to have standing. The courts are reactive. But as Senator Whitehouse laid out, there's a whole network of groups that fund and develop and present test cases over and over and over. And this is an issue that'll be before the court just a week after the election. that is really not distinguishable from NFIB versus Sebelius. I mean, they are essentially about the constitutionality of the mandate, whether it's a legitimate exercise of the taxing power. You don't get to the question of severability if you haven't already determined the question of constitutionality.
But I think that the question of severability, even if the now zeroed out mandate provision is a penalty, it doesn't affect the act at all. If that provision can be severed out, then the whole rest of the act would stand. And so I actually think that severability is sort of the, I think severability is one of the most important issues in the case. I don't think the question of characterizing it as a tax versus a penalty, NFIB versus Sebelius also was interpreting a different provision. It was one that wasn't zeroed out, that actually had money attached to it.
But if I could, this is the filing of the Department of Justice in the Supreme Court. As you well know, the Justice Department is supposed to defend the constitutionality of federal laws if any reasonable defense can be made. And the Trump Justice Department has sided with those advocates who are trying once again to strike the law down now in the courts when they couldn't accomplish that here. In fact, I'd argue that they're denying the will of the voters that clearly in 2018 in deciding control of the House on health care want this to stay. And the administration's arguing that this now toothless mandate, which imposes no payment on anyone, is unconstitutional, and they're arguing the entire act must be struck down as a result. I frankly think the DOJ is embarrassed by this brief. They rarely even talk about it, but it's in black and white in the quotes over my shoulder that the mandate is unconstitutional and must go, and so the parts of the law that prevent insurance companies from discriminating against people with pre-existing conditions, that prevent discrimination against women, all of it must fall as a result. It seems to me that Americans who are watching deserve to understand that this is somehow back up in front of the court, the posture the administration is taking, the ways in which it really does follow some of the contours of NFIB versus Sebelius, and the ways in which, bluntly, well, I know you won't talk about this pending case, what you said in that 2017 article, what you wrote, is highly relevant. Just as a preliminary point, the vote to uphold the ACA in NFIB versus Sebelius was 5-4, correct?
Yes.
And Justice Ginsburg was in the majority and Justice Scalia in the minority.
Yes.
So if you were to replace Justice Ginsburg with someone who followed precisely Justice Scalia's analysis on the linchpin question of constitutionality, one could expect it would be overturned.
No, Senator Coons, because if there were a direct challenge to NFIB versus Sebelius, there would be precedent on point. And the law of stare decisis is a whole body of doctrine that binds judges itself. So, no, I don't think one could assume that in a separate point in time that even Justice Scalia would necessarily decide the case the same way once there was precedent on the books.
I agree, and I look forward to discussing that in some more detail tomorrow. I have just, I think, 6 minutes. Your views of precedent, Justice Scalia's views of precedent, and the ways in which they may diverge, I think are important, and important for us to spend some time on. Let me just recap this point. For President Trump, for Republican politicians, the argument about tax and about whether or not the mandate is a tax is the gateway to knocking down the entire Affordable Care Act. And that's also the line of attack being taken by the Department of Justice. You've already said it's not plausible to interpret the mandate as a tax. If you didn't think it was a tax when it was raising billions of dollars in revenue, you certainly, I think, are unlikely to believe it's a tax when it raises no revenue. And the thing that might distinguish it from NFIB versus Sebelius is reliance interests and precedent. And when I have more time tomorrow, we'll go through that. But I just wanted to connect some dots. That Trump has repeatedly vowed to get rid of the ACA, has campaigned on it, has criticized the Chief Justice, has said his nominees would do the right thing. His administration is in court right now, arguing in a case to be heard in just 4 weeks, that it should be invalidated. And a person you've criticized, Chief Roberts, a person whose opinion, whose decision you have criticized, Justice Roberts, means in many ways that you've signaled, I think. You were added to the Supreme Court shortlist after you wrote that article. And today, my Republican colleagues, who themselves have promised to repeal the ACA, are rushing through your nominations so you can be seated in time to hear this case. It concerns me gravely that that's the circumstances we're in. Let me ask one last line of questioning, if I might, in the 5 minutes I have left. There's another subject on which President Trump has been, I think unfortunately, very, very clear about what he hopes for from a Supreme Court nominee. Just days after Justice Ginsburg passed, the president was asked why there was such a rush to fill her seat before the election. And he responded, and I quote, "We need 9 justices. You need that. With the millions of ballots that they," and he meant the Democrats, "are sending, it's a scam, it's a hoax. You're going to need 9 justices." The next day, he told reporters, again, he doubled down, "I think this," and he means the election from the context, "will end up in the Supreme Court. It's very important. We must have 9 justices." Our president has also been asked whether he'll commit to a peaceful transition if he loses the election. He's been asked directly and repeatedly. And instead of responding in the way we'd expect of any leader of the free world, with a clear and simple yes, he's tried to sow confusion and distrust in the potential results. So, Your Honor, I'm concerned that what President Trump wants here couldn't be clearer, that he's trying to rush this nomination ahead so you might cast a decision, a vote in his favor in the event of a disputed election, and he's doing his level best to cast doubt on the legitimacy of an election in which literally millions of votes have already been cast, most of them by mail. I was very encouraged, again, to hear from you specifically. You have not had any conversation with him about this topic, and that's not what I'm suggesting. In fact, you repeated promptly 28 U.S.C. 455. You're quite familiar with the recusal statute and its considerations. But I think the gravamen, the core issue in recusal is that any judge or justice should recuse themselves from a case in which their impartiality might reasonably be questioned. Given what President Trump said, given the rushed context of this confirmation, will you commit to recusing yourself from any case arising from a dispute in the presidential election results 3 weeks from now?
Senator Coons, thank you for giving me the opportunity to clarify this, because I want to be very clear for the record and to all members of this committee that no matter what anyone else may think or expect, I have not committed to anyone or so much as signaled. I've never even written. I've been in a couple of opinions in the Seventh Circuit that have been around the edges of election law, but I haven't even written anything that I would think anybody could reasonably say, oh, this is how she might resolve an election dispute. And I would consider it, let's see, I certainly hope that all members of the committee have more confidence in my integrity than to think that I would allow myself to be used as a pawn to decide this election for the American people. So that would be on the question of actual bias. And you asked about the appearance of bias.
Correct.
And you're right that the statute does require a justice or judge to recuse when there's an appearance of bias. And what I will commit to every member of this committee, to the rest of the Senate, and to the American people is that I will consider all factors that are relevant to that question. That requires recusal when there's an appearance of bias. And there is case law under the statute. And as I referenced earlier, in describing the recusal process at the Supreme Court, Justice Ginsburg said that it is always done with consultation of the other justices. And so I promise you that if I were confirmed and if an election dispute arises, both of which are ifs, that I would very seriously undertake that process and I would consider every relevant factor. I can't commit to you right now for the reasons that we've talked about before, but I do assure you of my integrity and I do assure you that I would take that question very seriously.
Thank you, Your Honor. Just on the question of consultation, the former Chief Justice Rehnquist, because this question came up in 2004, wrote a letter actually to members of this committee that there's no formal procedure for court review of a decision by a justice in individual cases. It's just something, Justice Ginsburg did say that there was a practice of consultation. I do think at the end of the day what matters is removing any potential conflict here, ensuring that there is confidence in our election, in the Supreme Court, and in its role is critical. I have reached out to a number of my colleagues to implore them to step back from the timing of this confirmation, to consider the possible confluence of three different factors here, an election, an ACA case, and a rush timing in the middle of a pandemic. And I would just urge one more time to think seriously about stepping back from this timing of this confirmation. That's not meant to impugn you or suggest that in some way you've engaged in some inappropriate conversation. That's just the confluence of these events at this time in this place. This election will have enormous consequences. I am troubled by what you've written about the Affordable Care Act. I am more concerned that the president has tried over and over and over to get rid of the ACA and that the American people have consistently said no, and that the consequences for a majority of Americans who rely on the ACA in the middle of a pandemic would be significant, and that the president has refused to embrace the American people's wishes and deliver some compelling alternative plan, and instead has taken the battle back to the Supreme Court, where it will be heard in just a month. I think to reach out and to strike this critical statute down now would be the worst example of judicial activism, which my colleagues say they don't want, and which I hope will not happen. But I am gravely concerned by what I see. Your Honor, I believe your views are sincere, but I also think you genuinely think the Affordable Care Act is unconstitutional. That's my reading. And you are entitled to that view. But this body and the American people, we shouldn't kid ourselves. Bluntly, if our president and the majority are able to swing the court out of balance by replacing Justice Ginsburg by someone whose views may be significantly to the right, the health of a majority of Americans may well be in peril. Thank you, Your Honor.
Thank you, Senator Coons. Judge, if it's okay, we'll do Senator Hawley's 30 minutes and take a break. Is that
Sure.
okay with you?
Yep.
Senator Hawley, you're on deck. We'll try to take a 15-minute break. And just one observation, really a lot of good questions, good interchange. Not one time has a senator and the judge talked over each other. I hope the American people understand that this is the way that it should be. Senator Hawley.
Mr. Chairman, thank you. I'd like to begin by asking consent to enter 2 letters into the record supporting the judge's nomination, the first from the Family Research Council and the second from a group of state attorneys general, including the state attorney general of my home state of Missouri.
Without objection.
Thank you very much. Judge, it's good to see you again. I've been so impressed with your answers today. It's really quite extraordinary. I look forward to visiting with you a little bit here. Can we just start on the topic of independence, picking up where Senator Coons just was questioning you? I've heard my Democrat colleagues over and over again suggest that because I guess you clerked for Justice Scalia that you'll automatically vote however he did. They attribute his opinions to you, his decisions to you, his method to you. Does Justice Scalia tell you what to do in your career? I mean, have you been in the habit, your life, of doing exactly what Justice Scalia told you to do in your professional career?
Well, Senator Hawley, as I said earlier, if you confirm me, you're getting Justice Barrett, not Justice Scalia. You know, I share his method of interpreting the text, but, you know, I didn't agree with him in every case, even when I was clerking. I mean, then he could tell me what to do, and even if I disagreed, I had to go his way. But the fact that we share the same approach does not mean that we would always reach the same result.
And you make up your own mind, don't you?
I do make up my own mind.
And you have your own views, I think it's fair to say. Is that accurate?
Indeed, I do.
And you're a very accomplished jurist in your own right. Is that fair to say?
Well, it feels a little immodest to opine on that
Well,
question.
I'll say it is. You're very accomplished. So I think this one-way attribution that everything, that you must just be whatever Justice Scalia did, you would automatically do, I have to say, frankly, I think is a little bit demeaning. Let me ask you about some other attacks that you've endured today. Now, I noticed yesterday we were assured that you would not be attacked on the basis of your faith. I noticed that didn't last 24 hours. But I'm not surprised because for 3.5 years, we have heard consistent attacks from the Democrat side on nominees on the basis of their faith, including, of course, you, Judge Barrett, and we talked about this some yesterday. Today, the second Democrat senator to speak criticized you for speaking to a Christian legal group that has a program, a summer program for Christian law students, where you gave, I think, a lecture once or twice on constitutional and statutory interpretation. So let me just ask you about that. You've talked about your faith. This has been well established. You accepted an invitation to speak to a group of Christian law students on the topic of your specialty. Tell us why you accepted the invitation.
I had several other colleagues who had participated in the Blackstone program lecturing, and I heard great things about it from them. We had a contingent of students from Notre Dame regularly attend this program, and they were among our most engaged and smartest students. And I went and did it. The first time I did it, I really enjoyed it. The students were very, very engaged. So I did it, I don't know, I might have done it 4 or 5 times. Each summer I would go and just give a lecture on originalism that was 1 hour of the, Blackstone is a summer-long program. So I went and gave my 1-hour lecture at the beginning of it, and I really thought it was a fun. To talk about the Constitution to an engaged group of students is fun for someone who's a law professor.
Are you aware of anything in the Constitution or our laws that say that it is a disqualification for office for a believer of religious faith to go and lecture to law students of a similar faith in her area of expertise?
I certainly, let me see, I want to be careful that I'm not veering into answering hypothetical questions, but I certainly didn't think there was anything wrong with my going to speak to a group of Christian law students about my expertise.
Let me ask you this. Senator Leahy also raised a pledge, a statement that you signed regarding abortion. You told us, you told the committee in response to his question, you and your husband both signed it. I'm looking at the advertisement in question right here, the portion that you signed. You said that you signed it on your way out of church, if I remember correctly.
I did. That was almost 15 years ago. At the back of church, there was a table set up for people on their way out of Mass to sign a statement, validating their commitment to the position of the Catholic Church on life issues. The ad that was next to it, I don't recall seeing the ad at the time, and in context looking at it, it looks to me like that was an ad by the St. Joseph County Right to Life group. The statement that I signed, it was, affirming the protection of life from conception to natural death. Oh.
And you just made reference to the fact again that it was in church. Can you just, why would it have been in the back of church? I mean, why would the signatures, why would this have been available to sign or not, as you so chose in the back of church?
Well, because that is the position of the Catholic Church, on abortion. Though I feel like I should emphasize here, as I emphasized to others asking me the question, that I do see as distinct my personal, moral, religious views and my task of applying the law as a judge.
Is it safe to say, following that distinction you just made, though, that the signature that you lent your husband also reflects your understanding of your church's teaching and your own personal views? I mean, that's what this says that you signed. So
what I would like to say about that is I signed that almost 15 years ago in my personal capacity when I was still a private citizen. And now I'm a public official. And so while I was free to express my private views at that time, I don't feel like it is appropriate for me anymore because of the canons of conduct to express an affirmative view at this point in time. But what that statement plainly says is that when I signed that statement, that is what I was doing at that point as a private citizen.
And I'm not aware of any law or provision of the Constitution that says that if you are a member of the Catholic Church and adhere to the teachings of the Catholic Church, or you have religious convictions in line with those of your church teaching, that you're therefore barred from office. Are you aware of any constitutional provision to that effect?
I would think that the religious test clause would make it unconstitutional.
Well, let me just ask you about the test clause since you bring it up. Article 6 says, no religious test shall ever be required as a qualification to any office or public trust under the United States. Can you just give us your sense, as a constitutional expert, scholar, and judge now, of the significance of Article 6 for our constitutional scheme?
So the religious test clause prohibits this body, prohibits the government generally from disqualifying people from office because of their religious beliefs.
And it guarantees, does it not, the freedom of religion? I mean, it is Amendment 1, the First Amendment, will go on to talk explicitly, and I want to ask you about that in a second, about religious liberty. But Article 6 is significant in that it sets out that no American citizen can be kept out of office based on his or her belief. You don't have to go and get someone's approval, certainly not somebody in government, their approval over what you believe. Does it meet this test or not? Do they like it or not? You don't have to get any sign-off. In fact, any kind of sign-offs are explicitly ruled out by the Constitution. Is that a fair characterization?
The religious test clause makes plain that denomination or belief can't be a reason to disqualify someone.
And that is why I continue to say it is vital that we underline in the Constitution that this test clause, and that we insist that it be applied in the context of your confirmation judge and every nominee for every high office who comes before this committee. There are no religious tests for office, and the attempt to smuggle them in, even in the midst of this committee's hearings to date, it must be resisted on the basis of the Constitution itself. Let me ask you about the First Amendment, about the free exercise of religion. That's, of course, how the First Amendment begins. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Tell me what you think this says about the place of religious observance in American life and its significance. Why is it protected like this in the First Amendment? What do you draw from that?
I mean, I think its presence in the Bill of Rights, you know, like all of our rights, shows that it was one that the people, for generations beginning in 1791, considered central to being a free people.
And there's no indication from the Constitution that religious believers are second-class citizens in any way, is there?
Well, the free exercise certainly suggests to the contrary.
And in fact, the Free Exercise Clause and the First Amendment suggests that the exercise of religion, worship, religious belief gets special protection. I mean, it's singled out here for protection, along with, immediately after, speech, press, right of the people peacefully to assemble. Religion is given a special place, which the United States Supreme Court has recognized. Let me just ask you about attempts to disfavor religious believers on the basis of faith. Is it your understanding, can a government at any level, federal government, state government, municipality, whatever, can they treat religious believers differently? Can they single them out for disfavor versus a non-religious group? Is that permissible in our constitutional order?
Well, Senator Hawley, that's a complicated question because, you know, there's a lot of doctrine surrounding that, and there aren't bright line rules, and so that question would come up in a case with facts, and, you know, it would require the whole judicial decision-making process. So it's not a hypothetical that I can answer.
Let me ask you about the court's decision, unanimous decision in the Hosanna-Tabor case, which touches some of these questions, in which the court there, it's a question about church's ability, any house of worship, to hire and fire their ministers or those who perform religious functions, religious services. And in that unanimous decision, the court says that houses of worship are different, that they are unique, that they are given special protection under the First Amendment, and that therefore they must be accorded special status. They have to have the ability, for instance, to hire and fire ministers, those who are going to perform religious functions. The state, the government cannot interfere with that. Do you agree with the teaching of that case? I mean, do you think that case remains good law and is a significant decision?
Well, Senator Hawley, I think the way to answer that question is, again, as I've said, I can't grade precedent, but I can talk about a precedent from my court. So I was on a panel that decided a case called Gruscott, which applied Hosanna Tabor to the situation of a Jewish school which had fired a teacher, and the teacher sued, and the question was whether, following Hosanna Tabor, that school was entitled to treat her as a minister under the ministerial exemption recognized in Hosanna Tabor. And my court, the panel that I was on, said that she was a minister, and we, took the factors in Hosanna Tabor and said nothing was a bright line test. You look at the cluster, because Hosanna Tabor was designed to give religious institutions the freedom to hire and fire their ministers, in this case, one of the Jewish faith, as consistent with their practice of their faith. And that view of ours in Gruscott was embraced by the Supreme Court last term in Our Lady of Guadalupe.
I think it's vital in this time, in this season, Judge, where we're seeing many challenges to religious independence, many challenges to the ability of churches to conduct worship on equal terms with secular organizations, that the Supreme Court's unanimous decisions in this area, Hosanna Tabor and others, the Trinity Lutheran case, which was not unanimous, but is a recent, very important case as well, I will just say for myself that I think that the lines that the Supreme Court has drawn regarding the First Amendment, regarding the status of houses of worship, regarding the rights of religious believers, that now more than ever, it is vital that those be respected and that the Constitution be fully enforced, and that the line of cases that is now multi-years old that the Supreme Court has set out be followed. And I certainly hope that you will respect and apply that precedent going forward. I don't have any reason to think that you won't. Let me shift gears and ask about another attack that has been made on you today, having to do with the Cantor case. The Cantor case we've heard about, Senator Durbin asked you about it at some length, Senator Klobuchar asked you about it as well. The Cantor case, first of all, is a case about the Second Amendment, the right to keep and bear arms. Is that right?
That is right.
And it's about whether or not someone who had been charged with and convicted of or pled guilty to a felony could keep and bear arms under certain circumstances. Is that a fair summary? Yeah. Now, I've heard repeatedly from my Democrat colleagues that you write in your dissent, you dissented in this case, you write in your dissent that the right to keep and bear arms is an individual right, but the right to vote is not an individual right. But maybe I'm reading a different opinion. That's not what you say in the opinion that I see. Page 50 of your opinion, or of the joint opinion, your dissent, you refer to civic rights, voting rights, as civic rights, and you say civic rights, you define them. Civic rights are individual rights. A moment later, you say, for example, the right to vote is held by individuals. So let's just set the record straight here. In this case, you say that the right to vote is an individual right. Is that correct?
That is correct.
And the distinction between a civic right and the Second Amendment has to do with the purposes of that right. First of all, that's not a distinction you invented. Is that correct?
That is correct.
You were replying to both a chain of cases and also scholarship on this issue. Is that correct?
That is correct, and also the arguments the litigants made in the Cantor case itself.
And this designation of a civic right talks about what the right to vote, what its civic purposes are. In other words, it gives us a stake in our democracy. Is that fair to say?
Yes.
So you never at any point say that the right to vote is somehow secondary or less fundamental than any other right. Is that fair to say?
Yes, that is fair to say. I never said that.
In fact, your whole point in this case, which is a fundamental rights case, doesn't have anything to do with voting rights. This is not a voting rights case, is it, the Cantor case? It has nothing to do with voting rights. Your whole point in this case, a fundamental rights case, is that you think that your colleagues on the Seventh Circuit actually constricted fundamental rights too narrowly. That is, the Supreme Court of the United States has said in Heller that the right to keep and bear arms is a fundamental right. That's the Heller decision. You think in this case that your colleagues actually were constraining that fundamental right a little too narrowly and were shutting some people out of it. Is that fair to say?
We did disagree about the scope of the right.
So just to make the record perfectly clear here, the Supreme Court has said, the United States Supreme Court has said over and over that voting, the right to vote is a fundamental right. And I think you have affirmed that and recognized today, you've said that is Supreme Court precedent. Am I right about that?
Yes.
And the Supreme Court has said repeatedly that they adhere to the one person, one vote standard, the sort of baseline, the touchstone, the keystone to that entire doctrine. Do I have that correct?
Indeed, that is correct.
And nothing in your opinion challenges that or changes that or calls into question, critiques, nothing, right?
Not one iota.
Okay. I'm glad that we're clear on that. Now, Senator Durbin said as part of his line of questioning on this, he suggested that, I don't know, perhaps that your opinion in this case somehow, which has nothing to do with voting rights, makes you friendly to what he characterized as attempts to deny people the right to vote on racial grounds. He went on to say that we all come to, every judge, all of us who come to the law, every judge who comes to the bench comes to the bench into cases with their own individual experience and viewpoints. So let's just talk about that for just a second, if we could, when it comes to the fraught but vital issue of race and your own experience with that. You and your husband are the parents of a multiracial family.
We are.
Can you give us some sense, just in your personal experience, what that has been like for you, what that means to you, what experience you bring to the bench because of your experience as a parent in this unique context?
Well, I think I could say how it has shaped me as a person. It has certainly, whenever you have a life experience, it makes you acutely aware in your interactions with other people. It gives you empathy for them. I mean, the same is true of our having a son with a disability. But I want to make very clear, Senator Hawley, that while my life experiences, I think, I hope have given me wisdom and compassion, they don't dictate how I decide cases. Because, as we discussed before and have discussed a couple of times, sometimes you have to decide cases in ways where you don't like the result. So while I hope that my family has made me a better person, and my children definitely have given me new perspectives on life, I still, in applying the law and deciding cases, don't let those experiences dictate the outcome.
You'll follow the law wherever the law leads.
Yes.
Which I think is a good way to bring us back full circle to where we started about your own independence. You've cultivated, I think it's fair to say, over the course of your very distinguished career, you've cultivated a reputation for original thinking, for independence, for, I would say, for courage and for toughness. And you've never, I see no evidence in your record that you've ever compromised, kowtowed, or bent your position to the whims of other people, especially people in power, based on what they wanted you to do or expected you to do or told you to do. Is that fair to say? I mean, have I missed something in your record?
No, I think that is fair to say.
I admire the way in which you've answered these questions, Judge, and your forthrightness on these issues, and I look forward to talking with you more tomorrow. And with that, Mr. Chairman, I yield back my time.
Thank you, Senator Hawley. We'll reconvene in 20 minutes, and we will go to about 6:30 and take a 30-minute break to have some dinner and come back and finish out round one today. So 20-minute break.